Oh, okay. I think that's what option. Sure.
Can you hear your name? Please stand up.
All right, everyone, please have a seat. And I am going to call docket. Today is Friday. Everybody should be excited because it's almost the end of a work week. So let's not turn today until Monday. Let's keep it as a happy Friday. When I call your name, let me know you are here. And the only people who should be sitting on the front row on this side is if you are late. Yes. It amazes me. People want to be on the front row in court, but nobody wants to be on the front row in church. The pastor always has to call everybody down and force you on the front row. All right. In custody, we have Victor Gelman. Carlos Martinez. Carlos Martinez. Is he in custody or not? Victor Morin is in custody. Robert Trevino. Robert Trevino. Thank you. Cameron Salazar. Thank you. Megan Tierney. Okay. And so is her file there? Has she been transferred there?
Yeah.
All right, thank you. John Gonzalez. John Gonzalez. In custody is Jesus Alejandro. Taylor Valdez. Melissa Carlson. Melissa Carlson. Naron Alexander. Thank you. Did I pronounce your first name correctly? Thank you. Autumn Bolden. Autumn Bolden.
I'm here, Your Honor. She's usually here.
All right, thank you. Trey Dion Johnson. In custody is Sky Anthony Gonzalez Daniels. Zinnia Para. Fernando Zepeda. Thank you. Dan Valadares Rodriguez.
President Counsel.
All right, where is he? In custody, we have Chadrick Walker, Kavan Rangel, Sergio Martinez, Stephen Ward, Christopher Edwards, Tuska Hamrick, Rosalie Morales, Megan Moran.
Good morning, Judge. President Counsel.
Thank you. Genesis. Help me with my double L's.
President Counsel, Judge.
How you say your last name? All right, thank you. I'm learning my double L's. Orlando Hernandez. Yvette Garcia. Logan Armstrong.
Your Honor, I communicated with her yesterday. I expect her here. I'll call her.
Thank you. Bryce Clark.
Judge, I spoke with him yesterday. I'll give him a call.
All right, attorneys, you need to start giving your clients rides. Let them come to court with you. Gilbert Alcorta. Jody Ochoa. Mark Lewis, as in jail. Talia Harris. Roland Hernandez. Thank you. And custody is, Utambasi Equerry. Lamont Curry. Was he supposed to be on the docket today?
He's excused, Judge.
Okay,
He's on the docket, but he's excused.
all right, thank you. Corwin Campbell, Carlos Castillo, thank you. In jail, we have Jesus Alejandro, Darrell Lewis, Sergio Martinez, Charles Garley,
President Your Honor.
Erica Lopez. Thank you.
President Counsel, Your Honor.
Felicia Cox.
Your Honor, she was actually accepted into drug court yesterday.
All right, thank you. Kevin Lawwill. Daniel Camarillo. Thank you. Jacqueline Wallace is in custody. Juan Ratana is in custody. Is there anyone who came in late or your name was not called? Yes, what is your name? And stop chewing gum. All right, you need to get on the front row. Who else came in? Did you come in late? All right, so that's late. What's your name? All right, you need to go on the front row. What's your name? All right, just have a seat. We'll get with you. Anyone else who came in late or your name was not called? All right, everyone. So here are the rules of the court. Please listen carefully and please follow these rules, because if you do, everything will go smoothly and it will still be a great Friday, even though we are working and not retired as we assume we would be when we were in our 20s, which I thought. So the state has their boxes of files. Grab your file, sit it on the state's desk and take your seat, because I'm trying to keep the area as least congested as possible. The state will call you and they're going to call you in the order in which you appear. So first will be first and last will be last. Once you've conferred with the state, confer with your client. You need to confer with your client. If your client is in custody, ask the deputy, they will bring them out. Do not approach if you have not conferred with your client. Do not approach if your client is not here in the box. Once you've conferred and you want to approach the court, grab the file from the clerk. Please take your seat. Again, I will call you in the order in which I'll receive your file. And again, first will be first and last will be last. All paperwork needs to be turned in by 12:45. If paperwork is not turned in by that time, we will see you on another day, which probably will be inconvenient for you. So it's Friday. Put a smile on it to make the day better, and let's confer.
Good morning.
Well, it should be in process, not on the. That's gonna cover that. He's not on the docket.
Yeah. Let me,
All right, Autumn Baldwin.
I'm not on that one, Your Honor. I shouldn't.
Is there a reason Autumn Baldwin? All right, just one
No
second.
problem, Judge. You know, I'm patient.
Yeah, I appreciate that. Okay, everybody. Park the C. All right, who's here on Adam Baldwin? I'm sorry, Autumn Baldwin. Yes. Are you ready to approach on this, Mr. Callahan?
Still confirming.
All right, thank you. Caroline, can you just file that? Yes.
If I may, Your Honor, Julian Palacios was on the front row. He was not on the docket for today that you did not call. He was the one last month that didn't have a phone. You gave him a date to come in today. He now has a phone. We have contact. He's not been invited yet.
Okay, can you have him come forward?
Sure. Mr. Palacios,
And did you want to speak to the state about it? What is he charged with?
it's 1 to 4, Your Honor.
So they probably don't have the
I
drug
don't have
resuscitation
anything
thing.
back yet,
Okay,
and I haven't seen it in the discovery. He already closed that.
okay. Hello, sir. Good morning. Hi. So you were here today to make sure that you and your attorney made contact so you can exchange information. And your attorney will always know how to get in contact with you, okay?
And I have on the reset from last month, I have the number, Your Honor.
All right, thank you.
Thank you.
All right,
Can
then,
we come back when he's indicted here in Orlando?
yes, or any other time, your attorney can request that you be placed on the docket, or either the next time we see you will be when your case is indicted. You may want to check in the back to just make sure he has his correct address and everything
Okay.
on file, because that's where they're going to send the information for your court date. So just make sure, and the clerk in the back can look up and see if they have his correct address on file.
Can we go out this way? Your
Yes.
Honor? Thank you very much.
Yes. Okay. Yes. Okay. All right, Norma, can you give this to family violence and tell them if they're okay with just letting him terminate? All right, who's here on Orlando Hernandez? Deputy Laura, who is this at the door? Is there a reason for the shades? Is there a medical reason for that? Is there a medical reason for the shades? Or are we just being fashionable? I don't know. Mhm. All right. Have you conferred with the state?
I have, Your Honor.
Have you received all the discovery?
We're still missing some discovery, Your Honor.
State?
Yes, Judge. He let me know this morning and I am gonna work on it today. It's videos.
Where are these videos from?
What-
Yeah, so to give a synopsis, Your Honor, there is an arresting officer. The contact made at the school administration office, and the video begins in the parking lot. I believe that there's probably video from that first contact.
So is this videos from the school? That's what I'm trying to get. Whose video is missing?
The school police. as well.
Okay.
It's a ISD case.
And do you all know if they preserve the videos?
We don't know if they exist. This is the first time we've discussed the case. Well, yesterday, Shimon came in early to talk about it.
All right, Norma, on Orlando Hernandez, if I can have a 1-month reset for discovery, please. All right, get a reset form and we'll see you back on November 4th.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. All right, that one's done. Ryan? Have you received this?
Okay.
Okay.
The first test you taken on that one.
Yes.
Okay. All right. What are we doing? He's gonna come back in 2 weeks or something like that?
Yes.
Okay.
Bryce Clark,
Your Honor.
good morning. Bryce Clark.
Oh, he's in jail.
Oh, he's in jail?
Yes, ma'am.
Oh,
No, he's not in custody. I guess he got arrested last night. I got a text back from the family member.
So how do we know he's been arrested?
So I get texts periodically from a girlfriend, so I'm assuming she has his phone and she texted me back.
All right, State. Is there any ways for you to find out if Bryce Clark has been arrested?
In this county or another county?
Where, counselor?
Not sure, Judge. All I got was in jail.
All right, so I'll need some sort of proof of that because, you know, just his girlfriend texting saying he's in jail. So if you'll talk to the state, otherwise a bond forfeiture is going to be issued. And of course, if we discover he's in jail, then that will change.
Right.
All right.
Okay, thank you.
May I approach you on it?
They're not ready on this. All right, thank you. Mr. Brown, they're trying to look that up now also. All right, Autumn Bolden.
Yeah, that's the quick.
Yes.
We have an agreement.
Okay, all right, thank you. All right, this is gonna be a plea. All right. Mr. Camarillo. Can I see the file on Daniel Camarillo? All right, how are you doing? All right, you're gonna have to speak up. I can't hear you. All right, so you were placed on probation, not under me, but under the previous judge. What have you learned?
I control my temper a whole lot better than I used to.
All right,
I usually step outside if I get into an argument or anything. I step aside and put myself to the side.
okay, you're talking very low.
I
And my
put myself-
allergy ear is
I'm
very
sorry.
clogged.
It's my, I will.
Okay, no problem.
Like I step aside, I step away from the argument. I control myself, give myself at least 10 minutes to control myself. I control more of my family now than I was before. Instead of drinking, alcohol and all that.
Mhm.
Stop that a whole lot of it.
Oh, yeah, you got to stop it completely, right?
And I'm not the same person I used to be. I mean, like I'm more of a family guy now. Go out to live with family, kids and everything. I do more quality time with also myself with my wife and now since I have a newborn on the way, so I'm like, I'm more kind of being true, how to say, be a better father, to an example, to my kids and stuff, how I used to be.
Mhm.
Pretty much, I've been trying to catch up with my probation and everything, but again, I have my support with my grandmother. She passed away, so now we got a house and we got bills now, so that's been kind of a budget for me on my side.
Okay.
I know 2030 on it.
Mhm.
I believe on my probation.
Yes.
And I've really been trying hard to pay for it. I paid $3,000 last year.
Okay.
And I mean,
So what do you do for a living?
actually, I just got certified. I'm a
Oh, sure.
I work for Caterpillar. I built the engine blocks for.
Oh, wow. Awesome. Congratulations.
So I'm trying to.
That's good work.
Yeah, so I'm trying to better my life and everything, but I have two other kids that I support too as well.
Mhm.
So I pay 200 towards child support to take care, maintain, to make sure they have their.
That's good.
And plus the insurance that they go with comes out to about 287, I believe.
Mhm.
So I also pay insurance to them. So it's like, it's kind of hard for me to, like I said, again, it's the financial part of having to struggle with.
Okay. And is your wife here today?
Yes, ma'am.
Hi, come forward.
Sorry.
Oh, that's okay.
Sorry.
No
I'm
problem.
awful.
Yes. So how's the relationship?
It took me in the beginning a while to get him where he's at right now. Right
Okay.
now, he's more calm to how he was before. I'm trying to make him more than I know he can be capable of. So I know he still needs to working on his GED. He's great at math, but he needs some like reading and like social studies. So we're working on it. So he can pass that and he can get his GED.
Okay, awesome. You have a good partner.
Yeah.
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 You should be very thankful because sometimes people won't take a chance on somebody. They see your history and they're like, not gonna take a chance. She took a chance on you. So you make sure that the fact that she took a chance on you, you celebrate that and celebrate her.
Yes, ma'am.
Okay. So you need to start thinking about what you're gonna get her for Christmas. And what you're gonna get her for just because, okay?
Because I'm carrying a ginormous baby.
Yes. Well, congratulations on the soon-to-be baby. Do you know if it's a girl or a boy?
It's a boy. It's another boy. I
Oh,
already
wow.
have one. I have a girl, boy, and a girl.
Ah. You know, you could name the baby Stephen. That's a play on the name Stephanie. All right, so this is what we're gonna do. The state is in agreement to terminating your case today, so you will be done with your case today. Okay, you're welcome. So we'll terminate him. And my understanding, he's finished all his classes. The only thing remaining is fees. So we'll just terminate him satisfactorily. All right, congratulations, you're done. And probation, is there anything you need to give him?
No, Your Honor, I'll get an order signed from you and let his officer of record know.
Okay, and if you two are off today because you came down here, you can enjoy the river walk. It's not so hot today.
I had to take the
All right,
day off
thank you.
today.
Thank you so much.
All right, you're
Thank
welcome.
you.
Have a great one. Bye-bye. Good luck on your exam. All right, who's here on Carlos Castillo? And is Mr. Castillo here?
Judge, I apologize, I'm not wearing a tie.
Why not? What does that mean? Can none of your fellow people pass you a tie?
Well, I guess Marcus could give me a, no.
Marcus is like, no. I don't know if Marcus' tie would go with that outfit, though. All right, so Mr. Castillo, on this case is going to start over. I don't know what the issue is going to be with regards to bonds.
I believe
Zoe and I have discussed it, Judge. This is Oscar Salinas for the record.
Oh, we're not on the
Oh,
record.
we're not on the record.
No,
Oh,
we're not.
Okay.
But I like that you said for the record. This is me just letting Mr. Castillo know, because I don't want him to be out and about enjoying his life and all of a sudden police show up at a picnic, or he's in line, if he has children, in line to pick up his children and he's handcuffed. So, yes,
He's on Full House Assist right now,
okay.
and I imagine that would continue on Full House.
Yes, I mean, the house arrest will continue, but what is going to happen with the bond issue?
So as far as the bond, the state would ask for 75,000. And that's, I think that's currently the current bond that he's on. We'd ask the same bond condition to be in place. He's no longer a sex offender because of what's happening today. However, the state would still ask that there be no contact with children except for his own child, and that contact be supervised.
How old is this child?
He's 8 years.
He'll be 9 next week.
Well, you all are going to have to fill out a motion, and you all are going to have to do an agreement of that motion. And Ms. Ferguson, on him, I need to request a PR bond evaluation so that I can get all the information I need to know whether or not I'm going to agree with what you all have come up with. So when can that be done? Because he's out and about, and technically he's not in custody. All right, so we're going to find out when that is, and we need to find out when this is going back on the docket.
Okay, I will say, Judge, looking at the file and speaking with with Zoe, Ms. Russell, right? Ms. Russell, I will be re-indicting it, and I will be looking at maybe adding additional charges and put myself in the best position to try him. Also, what I was talking to Zoe, there are 2 cell phone extractions that were done in this case. I have not looked at those cell phone extractions since they were with the previous prosecutor. Normally, we just hand over cell phone extractions. However, in this type of case, given that the victim was a 13-year-old, I need to make sure that there's no photos or any other type of images on there that prevent me from handing a copy over. And the same goes for his cell phone extraction. Make sure that there's no contraband on there that prevents me from handing it over.
Okay, so here's the issue. If he is going to be re-indicted, there's going to be a warrant out for his arrest.
So I would do it under the same JN, Judge, so it would not
Okay,
do an additional warrant.
all right. Because I think both parties are not expecting him or asking him to make another bond. Is that correct?
He's on whatever his current bond is.
Yes.
Yes, that's fine.
Okay,
So we can write up a motion
yes,
for you.
all right. And then this will be fast tracked to trial because everybody should already have everything. Yes,
So Judge, it sounds like Mr. Salinas has it from here. Can the CIU be excused from our role in this case?
and you didn't think to give him one of your ties because y'all are just.
Well,
You can have my vest if you want.
Yeah, they think like this one.
Oh, I appreciated that you, well, you know what? That would be a bold choice, so that's okay.
Yeah, there you go, right? For Friday.
All right, so file that, speak to Ms. Ferguson, and she'll let you know when to come back for a setting after she talks to find out about the PR bond evaluation. And it's not, again, it's not for me to give him a PR bond. It's just for me to get his history to make an informed decision on whether or not I'll go along with your agreement and also follow what the legislature is now requiring us to do. Okay, so if y'all will just wait right here in court, and Ms. Ferguson will give you a setting and she'll let you know where you need to be for that evaluation.
Thank you.
All right, thank you.
And Judge, may we be excused?
Yes, you're excused.
Thank you, Judge.
All right, bye-bye.
Thank you.
Oh, yeah, that's good.
Obviously, if you've got any other post-conviction stuff, you can give us a shout. The variance case.
Yes. That's very, could you make an exception? Because we're just told, I just need to find out what bond to place him on, or either we're gonna have to send it to Judge Carruthers.
Sounds good. Thank you very much. Have a good rest of the day.
And Norma, when do you think we would call this back? For a hearing on the bond? Okay. Okay. All right, thank you. All right, who is here on Megan Tierney?
That's the mental health.
Thank you. Who's here on Tuska Hamrick? All right. Tuska Hamrick.
This is the case that we have filed.
Oh, just 1 second. So where is he? Oh, is he a fugitive? He's not in custody or anything? Oh, okay.
We have filed a motion to withdraw and an affidavit of surety to surrender because
Yes.
he lost touch with us and you asked us to come back today to see if he showed up
Yes.
and he has not.
All right, just one moment. All right, we're going to go on the record. Court is calling 2022 CR 8246, State of Texas versus Tuska Hamrick. Could I have the parties approach and announce for the record for the state,
Marcus Sanders.
for the defense?
Daphne Probity for Sean Brown's office, Your Honor, for the defense.
All right, counsel, well, for the record, the defendant is not here. This hearing was scheduled at 9 a.m. It is now 9:35 a.m. Deputy Mejia, could you announce outside the courtroom to see if Mr. Tuska Charles Hamrick is out in the hallway?
No, Judge, he is not.
All right. So defense, have you had any contact with your client?
We have not. We made the bond in January.
All right, everyone in the box, we're on the record. If you cannot whisper, counsel.
Michael.
Michael Lemon.
I'm sorry.
All right, thank you.
Which case is that, Your Honor?
So, no, you need to be quiet in the box. All right,
We made the bond in January and we quickly lost touch with him. We've tried many ways to get a hold of him and he has not ever been responsive. So as the court date was approaching, we tried again in the beginning of September. We filed both a motion and affidavit of surety to surrender the bond under Code of Criminal Procedure 1719 that's file stamped September 22nd, as well as a motion to withdraw as counsel that's file stamped September
excuse me,
9th.
counsel. Michael. No talking in the box. We're on the record. Nobody can whisper. So wait. Sorry, you may continue.
I'm not sure where that I lost that, but so I'll just start over. We filed a motion and affidavit of surety to surrender under Code of Criminal Procedure 17.19 on this file stamp September 22nd, 2022, as well as a motion to withdraw as counsel. If we're not able to be in touch with him, Your Honor, it's very challenging to represent him.
All right, state, do you have any objections to the motion to withdraw?
No, Your Honor.
All right. And the motion to an affidavit of surety to surrender, that will be granted,
Thank you, Your Honor.
and the motion to withdraw is granted.
Thank you very much. Thank you very much.
All right. And with regards to the defendant's failure to appear, the court will issue a judge's warrant and remand the defendant without bond.
Very well.
Thank you. You're excused.
Thank you.
You're welcome. Thank you, you too.
Thank you.
Yes, that's all. Who's here on Charles Garley?
Morning, Judge.
Good morning. Let's see what page you are on. Good morning. Thank you for dressing appropriately for court. And I'm just trying to find you on the docket. Just give me a moment. Yeah. All right, so what is happening with this case?
Judge, I was speaking with the prosecutor yesterday. He's actually not present today. He was letting me know that there's an internal affairs investigation that stems from the incidents of this arrest. And so I know we were set for trial. We were recalled to today because another one went.
Mhm.
But based on that, I think we both agreed that it's best for me to try to subpoena those records just to see what's going on with that. Obviously, if there's any sort of discipline or anything like that, that may impact the way the state proceeds with their case. I've made also a counter offer for them to consider. They haven't told me no. I think they're still considering it. So at this point, just based on that information, I would request a 30-day reset, Judge.
All right, and state?
Yes, Judge. Daniel brought in the witness, who I guess is the officer on this case, and I guess during that time he learned about the IA thing. So I believe he's looking into it, but it's new information we got this week. So like defense counsel said, we're going to look into that and then consider their counter offer. But I know Daniel's looking into that.
Okay, so it's 30 days.
I'm sorry, Judge, there wasn't on the sound system.
Oh, okay, awesome. I thought it was like, should we move? Should we leave? So is 30 days enough time for everyone to?
I hope so. If I guess if not, we can get with defense counsel and approach the court. But I think we should be able to figure out something.
All right, so what day would we come back? Ms. Ferguson, 30-day reset? All right, so we'll be back on November 4th, and that will not be on the trial docket then. That will be for discovery.
Okay. Thank you, Judge.
You're welcome. You're welcome. Who's here on Bryce Clark? Hello.
Judge,
Yes, so
still no contact. I've called and now the text are being not even read at this point.
okay.
I spoke with him yesterday afternoon late, had a good conversation for at least half an hour.
Okay. All right, the court is calling 2022 CR 8299, State of Texas versus Bryce Clark. Could I have parties announced for the record for the state,
Marcus Sanders.
for the
Matthew Brown.
defense?
Matthew Brown, Mr. Clark.
All right, this hearing was scheduled at 9 a.m. It is now 9:41 a.m. The defendant has not appeared in court. Defense, do you have any idea where your client is?
I do not, Judge. I've received a text that says he's in jail, but I have no idea if that's him or a girlfriend. And telephone calls have gone unanswered at this point.
All right, Deputy Mejia, did you announce for Mr. Clark? All right, so according to the deputy, he made an announcement for Mr. Clark, and Mr. Clark is not outside the courtroom. State?
Judge, we're asking that his bond be forfeited and a warrant issued.
All right, that'll be granted. He'll be remanded without bond. If he makes an appearance, or if counsel, you bring the court information that the defendant is in custody, of course, the court will recall the warrant.
Yes, Your Honor.
All right, thank you.
Thank you.
That's a good one. Cameron Salazar.
Morning, Your Honor.
Good morning. So where are we on the PTD?
Everything's been signed, everything's been turned in. I think he's just waiting to go over and report and do whatever they need to be done, but everything's been done.
All right, when are we calling it back? All right. Continue to follow through on everything, okay?
Yes, ma'am.
All right, Ms. Ferguson will give you a reset form. And on this one, I'm just waiting on this one. They're not, yeah. How long these are done? This one, you need an interpreter. Okay. Okay, awesome. Thank you. Okay, what date do you want? Okay. All right, if I could see the parties on Daniel Valadares Rodriguez. Good morning. How are you doing today?
I am well here.
Yeah, you always brighten the day and it's Friday, so that makes it even better.
We are underneath this.
All right. All right, so we're not going to be on the record. I'm just trying to discover where we are on this case. So where are we?
Judge, we prefer to stay, and I think we'll need some problems.
Well, I mean, have you received all the discovery?
We have.
All right, I'll need a discovery acknowledgement filed today. Was an offer tendered?
Yes, Judge.
And when was it tendered?
It was a few weeks ago. We discussed it with them. We confirmed it today. We conferred with our client. So that's one thing.
All right. And is your client a citizen?
No,
All right, so he needs to have an immigration attorney appointed.
We have one.
All right. All right, so have you had an immigration attorney speak to him?
We have.
Okay, has a letter been provided?
Discussing his options, a formal letter, no, but we have discussed it.
All right, Ms. Ferguson, we're going to call this in 30 days. Make sure that if he needs a Padilla letter, which it appears that he does, that is done, and that he understands the consequences of entering a plea, not entering a plea, going to trial, not going to trial. And the court wants to make sure that he's aware of the consequences of whatever he chooses to do with this case. And Mr. Valadares, if you want a jury trial, the court will give you a jury trial, but the court does not like to have people in jury trial when they have not looked at their case in its entirety and made an informed decision. So we're going to recall this case in 30 days. Will that be enough time for the immigration issue?
It should be fine, Judge.
All right. Ms. Ferguson, can I have a 30-day reset, please? All right, so we're going to recall this for November 4th. When we come back on that date, one, I need to make sure, or counsel let me know that immigration has conferred with him on all of his options. And that will also be the plea deadline date. And so I'll need an acknowledgement of discovery today, and we'll be back on November 4th.
Judge, do you need a copy of the letter as well?
I mean, that's something you can have for your files.
Okay.
And if you want to file it, you can file it.
Okay, I just, some courts actually wanted me to file it. I've had others say they don't care. So, just wanted to ask.
I mean, it's really for your protection as well.
Okay.
All right, Mr. Valadares, do you have any questions?
yes, and you're telling me to go to trial. Because I haven't done anything I'm being accused of.
All right, so Mr. Valadares, I'm not here to listen to the facts of this case at this point in time. What is happening now is I am giving you a plea deadline date. That's November 4th. On November 4th, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, then the court will not consider any plea bargain agreements without good cause. If you want to go to a jury trial, of course, we will give you a jury trial and a jury will be here to hear your case. But before we have a jury trial, you need to have all the information about this case, and you need to have information as far as your immigration status and how this case will or will not impact that. All right, is there anything else, Mr. Valadares?
No,
All right, thank you. Yes,
thank you.
thank you. Always great seeing, yes, you may be excused.
When Norma called them.
Yes. All right, bye-bye. Who's here on Carlos Martinez? Thank you. All right, what is happening? Where's Carlos Martinez? Why not?
We spoke with him yesterday. He's supposed to be here, so we're working to try to get a hold of him. And my only issue that I'm running into today, Judge, is I'm going to be at a MABA event starting at noon.
So I don't know if I'll be able to come back if he shows up late.
All right, so I don't know if you want to stop back by at 10:30. What is the MABA event?
The golf tournament,
Ah, are you playing?
I am playing.
All right, are you going to go out there and do your family proud, or are you going to bring shame to your family?
Do my family proud, as always.
Yes.
We won last year, Judge.
Oh, hey. All right, now you just brag.
I
Don't
did.
make sure you went to, are
I
you
don't know if we'll
starting
do
a,
back-to-back, that'd be tough.
are you starting a dynasty?
No, I don't think so, not this year.
All right. So who's on your team?
Robert Greer, Chris Cavazos, and Eric Reynolds.
All right. Eric Reynolds sounds like a ringer.
He's pretty
All
good. Greer's pretty good also.
right. Why didn't you ask Marcus Sanders to be on your team or Ryan Groomer?
These guys, only four at a time.
I don't think they're golfers. I could be wrong on that. All right. So if you want to stop back by at 10:30 before you leave today to see if he's here,
Yes,
then we'll take it up.
And we'll work on call.
All right.
Thank you.
Thank you. You're welcome. Who's here on Francisco Reyes?
President Judge.
All right, so let me find him on the docket. All right, thank you. All right, state. On this case, you were, oh, violation report. Okay. All right, we're going to go on the record on 2022 CR 8087, State of Texas versus Francisco Reyes. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Ray Lopez.
And are you Francisco Reyes? All right, we're here on a violation report. So you're on bond on a County Court 7 case. The complainant in that case is Miss McCain. And then we have the offense date for that is September 15th of 2022. The offense date for this case is April 7th, 2020. And it's the same complainant. And you're here for a criminal mischief. So there's an issue. You see what the issue is? The issue is the offense date for this case, and mind you, I'm not accepting any of it is true. The offense for this case is April 7th, 2020. You picked up a misdemeanor case against the same complainant with an offense date of September 15th, 2022. Does anybody want to explain why he shouldn't be remanded without bond?
Yes, sir. There's an explanation. My client, and he can explain this to himself, he was at a football game when the second alleged incident happened. Saw when his son plays varsity football. He did not know the complaining witness was going to be there. When he did see her, the whole incident happened instantaneously. He did not have a chance to remove himself from the game, from the premises.
No, it's not about that. I mean, he's on bond out of my court for criminal mischief. And then allegedly, he picked up a new case against the same complainant. So it's not a matter of, I didn't know she would be there. It's a matter of, he's out of this court for a criminal mischief. And then allegedly, he picks up an assault family with the same complainant. And I don't know why people want to act crazy at a varsity game when children are just trying to play and have fun. I don't understand that either, but.
No, I just crossed paths. I was with.
But no. I don't know if you want, do you want to testify?
Oh, no, man.
All right.
I was just trying to defend myself, but it's. fine.
No. Do you want to testify? You want your client to testify?
No.
All right, so again, we're back to the point, why shouldn't I remand him without bond?
Well, judge was misunderstanding. He did not seek her. He did not go to her residence.
She was there by the time he was trying to remove himself, the whole incident happens. It's not like he was seeking her out or maintaining communication. They have a mutual trial together. The son that plays on the thing, he was just attempting to go watch his son play, did not think she was gonna be there. When she did, the whole incident happened and he did not have the opportunity to remove himself.
Well, again, my concern is not the fact that he had contact because he's at the game. My concern is allegedly there's an assault.
And we're disputing that case, Judge. He's seeking a trial on that one.
All right, state with regards to this violation report.
Judge, to be honest, I wasn't made aware of what the.
Do you want to?
Yes, and I'd like to, I guess, look up the new case also, if I could have a few minutes.
All right, I'll have you all step back and confer with the state. All right, thank you. Autumn Bolden. Why were you late for court?
I was riding the bus and the bus was late.
No, so here's the thing. I've ridden the bus before. I've ridden the bus when I was a defense attorney. And guess what? I knew that sometimes the bus would be late. You can take your hand off your hips. I knew sometime the bus would be late. So you know what I would do? I would take an early bus. And you know what time I would arrive at the courthouse? 7 a.m. And it worked out beautifully because early bird does really catch the worm. So you cannot be late for court anymore. If you're late for court again, what's going to end up happening is a warrant is going to be issued for your arrest. And we will hear your case and you will be brought over on time from the Bexar County Jail. You'll be dressed in a blue uniform because that's what they dress the ladies in, or either a red uniform or whatever uniform to signify your classification at the Bexar County Jail. Do you understand? Now, what is happening with this case? My understanding that this was a plea agreement. Is this not a plea agreement?
Unable to reach an agreement, you know.
All right. Do you have all the discovery?
Yes, ma'am.
All right. So your plea deadline date is today. So that means that after today, the court is not going to accept any plea bargain agreements in this case. And we were set today as your plea deadline date. So the court will not accept any plea bargain agreements in this case without good cause after today. So you will be going to jury trial. Do you understand?
Yes, ma'am.
Ms. Ferguson, what is the earliest jury trial date we can give Ms. Bolden? All right. All right, you're going to be back on December 6th and you're going to be sent to impact court. And I'm writing in the file that a plea bargain agreement is not to be accepted without good cause. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, we'll give you your setting.
Thank you, Judge.
You're welcome. And counsel, if you could make sure that the acknowledgement of discovery is done today.
Yes, ma'am.
All right, thank you.
And we'd be excused.
Yes, after she signs the reset form. All right, and this one, he's coming back. Deputy Laura, they're working on the sound system. Hopefully somebody will come and work on the AC.
Good.
Who's here on Genesis
Present, Your Honor.
Viela. Notice how I said that very softly. All right, and she needs to be in the center. All right, have you conferred with the state?
I have, Your Honor.
And have you received all the discovery?
Yes, and they made their first offer.
And this is the only case that your client has pending, correct?
That's correct.
All right, Ms. Ferguson, I need, I'm sorry, pronounce your last name. Viela, to come back in 2 weeks for a plea deadline date, please. I promise you, I'm really trying to work on my double Ls. All right, so we're going to come back on October 13th. At that time, you'll need to let the court know whether or not you're accepting the plea bargain agreement. After that date, the court will not consider any plea bargain agreements without good cause.
Thank you.
All right, thank you. Thank you for dressing appropriately for court. I appreciate that.
May we be excused?
Just get a reset form and then you can be excused. You're welcome. All right, Jacqueline Wallace.
Good morning, Judge.
Good morning. All right, your plea deadline date was actually set for yesterday, but I guess something happened, so we're here today for a plea deadline date.
I was in Seguin yesterday morning, but I believe that they hadn't brought her from the jail yesterday.
Okay.
So
All right, so where are we?
we do not have an agreement. We would request that this be placed on a trial docket, Judge.
All right, do you have all the discovery?
We do. In fact, they turned some over to us the other day.
And when you say other day, what does that mean?
Last Monday, I think.
And did you have a chance to review that new discovery with your client?
I have not. It is an audio recording of my client, some phone calls from the jail.
Okay.
So I will be going over that sort of stuff with her.
All right, then what I'll do, because people never know what's on the jail calls until they sit and listen to them.
We have an idea.
All
No,
right.
no, I've conferred with her about it.
All right, so do you wish for me to extend the plea deadline date so she can review the jail calls or no?
No.
Okay.
We've been negotiating enough.
All right, and state on each of these cases, I'll need the acknowledgement of discovery, and Ms. Ferguson, I need a jury trial date. Thank you. And are both these cases family violence?
They're all being handled by me.
Okay, and it's family violence, Ms. Ferguson. So how are you doing today?
I'm good, Judge.
It appears that LSU may be doing something. I don't want to jinx this.
I know they got up to a little bit of a rocky start, but hopefully.
Hopefully they keep climbing up the steps and don't get pushed back down.
He's a good coach.
Yeah.
I'm sure he's a good recruiter too. And obviously he's relying on Ed Ogeron's recruits right now, but.
Yeah.
They always have a pretty strong team.
Ed Ogeron's name should not be mentioned.
He won a championship for you.
But was it really his championship?
Go Burrow.
Yes.
Okay.
All right, so we're going to come back on October 31st, Halloween, for your jury trial.
Thank you, Judge.
All right, thank you. Is there anything else you need?
No, ma'am. And I'll sign this discovery acknowledgement.
Oh, Mr. Kuntz, that's going to be an impact court.
Okay. Do we know what judge will be down there?
No.
Oh, that's fine. I'm just curious.
Maybe it'll be me. Maybe I'll be in two places at the same time.
Who do you think you are, Mary or mine?
Yeah, yeah. Who's here on Yvette Garcia? All right. Hello, how are you doing? So where is Yvette Garcia? Okay. All right, we're going to go on the record. Court is calling 2022. Thank you. 2022 CR 8252, State of Texas versus Yvette Garcia. Could I have the parties announced for the record for the state? For the defense? All right. This hearing was scheduled at 9 a.m. It is now 10:09 a.m. Ms. Garcia has not made an appearance. Defense.
Judge, I did have contact with Ms. Garcia about a month ago, but I have not had contact with her. I have not had contact with her this morning.
All right, state.
We're asking that her bond be forfeited and a warrant issued.
All right, the court will grant the motion, forfeit her bond, remand her or adopt bond. If you make contact with your client and your client makes an appearance, the court will reconsider.
Thank you.
All right, thank you. Back on the record. All right, we're back on the record in 2022 CR 8252. The court has been informed that the defendant is on a PR bond. So the court will change its order and the court will issue a judge's warrant and remand her without bond. All right, is there anything else?
I believe you have another file there for Christopher Edwards.
Okay, just give me 1 second. And Caroline, this one is a judge's warrant. All right, let me find Christopher Edwards on the docket and we will take that up. Thank you. My ophthalmologist says you will let me put the line in your glasses when you get tired of taking your glasses off because I just need them for distance. And you know what? I told him, I'm not tired.
Well,
That's why I have these.
yeah, I tried the bifocals a couple of years ago. It really messed with my walking up and down stairs, riding, everything.
I'm not doing it. And you know, I thought about doing LASIK, but I think I will be in that 1% who loses vision. And then you two will have to, you know, walk me around and cook and clean for me.
You'll be the female version of Bertram.
Yeah, because you know what? I am, stop, that is so wrong. Because you know what? I am too old to start learning new things. I try. All right, we're gonna go on the record in 2022 CR. Okay, see, I need to give him the thing from Bambi with Thumper. When Thumper mom says, what did I tell you? And he's like, if you can't say anything good, then don't say anything at all.
I wouldn't be talking ever.
You're talking right.
I'm just speaking the truth.
Oh, yeah, he is. Okay.
Like saying I'm bald, like that's the truth.
That's what? I didn't know that. All right. Court is calling 2022 CR 8089, State of Texas versus Christopher Edwards. Could I have parties announced for the record? For the defense? All right, this hearing was scheduled at 9 a.m. It is now 10:12 a.m. Defense, have you had any contact with your client?
I have not, Your Honor.
And is this a PR bond, Ms. Ferguson? All right, have you attempted to contact your client?
I have, Your Honor.
And what are the results?
No contact, Your Honor. Unsuccessful.
All right, state.
We're asking that his bond be forfeited and a warrant issued.
All right, that will be granted. Your client will be remanded without bond. And the court will issue the bond forfeiture. If for any reason your client makes an appearance, then the court will reconsider.
Thank you.
All right, thank you. That's a beautiful top, by the way.
Thank you, Judge.
All right, have a great day. And this is a bond forfeiture. All right, Francisco Reyes. All right, we're back on the record in 2022 CR 8087, State of Texas versus Christopher Reyes. Can I have parties please re-announce state?
Marcus Sanders.
Defense?
Ray Lopez.
And are you Francisco Reyes? All right, so have you all had a chance to confirm the violation report?
Judge, I've had a chance to look at the new offense report and I provided it to defense.
Yes.
And so based on the violation report and the new offense, I guess we would be asking, I guess we don't have an agreement as to what we're asking for.
All right, state, what are you requesting?
Because we would ask for full GPS house arrest.
Judge, we would ask that no further conditions be entered against him. We fully intend to approve that those, the incident did not happen as states in the report. And we fully intend to prove that when he has his day in court on trial on that matter.
All right. We are back on this case on October 13th. The defendant will be placed on full GPS. Under this cause number 2022 CR 8089, 8087. And of course, there's to be no contact with the complainant. And that is Allison Lee, Leigh, McCain, McCann. Is there anything else from either side?
No, Your Honor.
No, Your Honor.
So, Mr. Reyes, do you understand that you're on full GPS? So what that means is if somebody's having a barbecue in your yard and they want you to come out and man the grill, you can't because your GPS is going to go off. If somebody says, hey, we have a plate prepared for you, and you step out on the back porch to grab that plate, your GPS is going to go off. And I'm going to get notification of that. And what's going to end up happening is we're going to be back here for another hearing, and you may end up having your case heard when you're brought over from the Bexar County Jail, either in an orange uniform like you see the gentleman wearing there, or red, or whatever classification they set for you. Do you understand?
Yes, Your Honor. Thank you.
All right. Is there anything else from either side?
No, Your Honor.
No, Your Honor.
All right. Thank you very much. And we'll see you all back on October 13th. All right, who are the parties on Jesus Alejandro?
Michael Latin, she's right
All right.
here.
Thank you. Did I see the case on Megan Moran?
But she has an ankle monitor on that case, and I guess he wanted to ask.
We could get it removed, Your Honor. Filed the motion on it a while back.
Oh, since it's being dismissed, it should be removed.
Wonderful.
All right, so if you want to go in the back, you guys are very close. It should be like ships passing in the night. If you have something to bring to me, just bring it up and then go back. Or either like the Lone Ranger, where I say, who was that masked man? You're supposed to leave so quickly. All right, I'll order on this case, the GPS is to be removed. And state. And is your client here today?
Yes.
Ms. Moran, please come up. Hello. Hi. So your case has been dismissed. So make sure you're careful as you go forward in life. You don't want to come back here for a misunderstanding or whatever, right?
Yes, ma'am.
All right, so it's a happy Friday for you. Go forth and enjoy your day.
Thank you.
They should be removing the GPS today.
Okay, awesome. Thank you so much.
All right, you're welcome. Have a great one. Enjoy the river walk. They should, you said you had an order file. I mean, if you want me to, yeah, if you want me to sign the order that you have, just have them pull it from the back. Otherwise, I've written it on the docket sheet, so it should be removed. All right. Yes. Do you see what page she's on, Moran? Thank you. All right, so we're going to go on the record. Court is calling 2022 CR 6208, State of Texas versus Jesus Alejandro. Could I have parties announced for the record for the state?
Ryan Grimmer for the state.
For the defense?
Mike Latimer for the defendant.
And are you Jesus Alejandro?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Alejandro, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, are you proceeding on the indictment as, I'm sorry, counsel, do you waive the reading of the indictment?
Yes, I do.
State proceeding on the indictment as presented?
Judge, I believe the only thing we're doing is we're waiving one of the two enhancement allegations and proceeding as a repeater, a second degree felony.
All right, let me see which enhancements you're waiving. All right, that would be the second paragraph that
That's
you're
correct,
waiving.
Judge. We're waiving paragraph 2.
Any objections?
No objection, Honor.
All right, Mr. Alejandro, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with the evidence or intent to impair? Normally, that's a third degree felony. The range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
State is proceeding on a repeater count if they present evidence to the court that's sufficient to find the repeater count true, then that will mean that your range of punishment will be in the range of a second degree felony, which is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Alejandro, has anyone threatened you, coerced you, or placed you in fear to get you to end this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, You are to agree that you've been previously convicted of one or more felonies for enhancement. Punishment is to be assessed at a cap of 12 years. There's a $500 fine. There's no application for deferred adjudication. The state opposes your application for community supervision. They will take in consideration County Court Cause number 682820, which is a resisting arrest detention. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is.
State, is that the plea?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Judge. State would offer State's Exhibit number 1.
We reviewed, no objection.
Mr. Alejandro, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of police reports, witnesses' statements, and judgments? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. With regards to the repeater enhancement allegation, which reads, and it is further presented in and to said court that before the commission of the offense alleged above, hereinafter styled the primary offense, on the 16th day of April AD 2008, and cause number 2007 CR 8298 in Bexar County, Texas, the defendant was convicted of the felony of driving while intoxicated, third or more repeater. How do you plead to that? True or not true?
True.
All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon States Exhibits 1 and attachments. We'll come back on November 29th for sentencing. The court will receive a PSI report. The court will base its decision on your application on the PSI report and any other evidence that is presented to me. Do you understand?
Yes, ma'am.
All right. Does a TAP evaluation need to be done?
I would recommend that, Your Honor.
All right, probation. I'll need a TAP evaluation and full PSI report on Mr. Jesus Alejandro. Thank you. Who's here on Fernando Zepeda?
I am Judge, he's present. I conferred with the state, he has an unindicted case that we're waiting on.
All right, Mr. Zepeda, come forward.
Morning, Judge.
Good morning. Let me just find which page he is on. Thank you. All right, state on Zepeda, what is happening with this unindicted case? And is that going to be controlling?
Indicted cases, Judge, and I told Mr. Garcia I would look at them and see if we're going to proceed on them, but I think it would potentially affect the offer.
All right, Ms. Ferguson, can I have a 30-day reset on Zepeda? And it'll just be a regular reset. All right, we're going to come back on November 4th to see what is happening with the unindicted cases. Just get a reset form for Ms. Ferguson.
Thanks, Judge.
You're welcome. You're welcome. Here you go. All right, who's here on Juan Ratana? All right, good morning. So where are we on these cases?
I'm ready for trial.
All right, Ms. Ferguson on Juan Ratana, I need a jury trial date.
October 31st.
All right, we'll see you back on October 31st, Halloween. You will be in impact court. Mr. Ratana, you will be brought over dressed for trial in whatever clothing you have at the jail. If you wish to be dressed in something other than what you have at the jail, you will need to speak with your attorney and make a clothing arrangement. If you do not sign the clothing exchange, he's not going to be allowed to exchange your clothing. Mr. Stenberg, if there's an issue with the clothing exchange, let the court know and we'll see what we can do to expedite that.
Yes.
All right, thank you. Always good seeing you, Mr. Stenberg. You're welcome. All right, we're done with Mr. Ratana. All right, is there a reason you're standing here, Mr. Halsted?
I wanted to approach on an off-topic matter, Your Honor. Just a quick question.
Yes.
I have a client who I wanted to see, would the court be willing to waive GPS fees? It's a pre-indictment case. Doug came and visited with you last week about getting the cost point.
Sure.
Do you want a formal motion for that or?
If it's just waiving fees, you can just have them printed B page.
Okay, I'll do that.
All right,
That
thank
was-
you.
Thank you.
Sure. Who's here on Victor Moran?
I am, Judge.
All right, the court is calling 2020 CR 5569 State of Texas versus Victor Moran. Can I have parties announced for the record for the state?
Catherine Pollard.
Warren Wolf for Mr. Moran.
And are you Mr. Moran? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Moran, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're waiving the repeater enhancement.
Any objection?
No, Your Honor.
All right, Mr. Moran, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault family second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state will call and the right to remain silent. Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
He has,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes.
Mr. Moraine, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. There are no applications. The state will take in consideration County Court Cause number 6900512. There's an affirmative finding of family violence. There's to be no contact with Teresa Chavarria. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your agreement? Defense, is that the agreement?
It is.
State, is that the agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Judge, we would offer what's been marked State's Exhibit 1.
No objection.
Mr. Moran, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements, judgments, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask that you follow the plea bargain.
All right, the court will sentence you to 4 years in the prison. There's a $1,500 fine, time and money to run concurrent. Taking consideration County Court Cause number 6900512. There's an affirmative finding of family violence. There's to be no contact with Teresa Chavarria. And credit for any time served. Is there anything else from either side with regards to sentencing? State?
Nothing from the state.
Defense?
No, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Moran, it appears that you have anger issues. You probably should not be in any relationship. And as it stands now, and I'm not trying to be mean to you, I'm just telling it to you straight. You are not considered a good catch. And let me just tell you why. You have criminal history. So these women who are wanting to be in a relationship with you, they're doing you a favor. So you need to get a hold of your anger, and the fact that you would go to a bar and assault someone at a bar in front of people, that tells me that you have strong anger issues. And I don't know what your issue is, but you need to take care of that. You understand? All right, good luck to you. Who's here on Ricky Coleman?
That's fair. I asked you that, John. We're just looking to waive the fees on the GPS.
All right, and does he only have one case?
No. That's
Oh.
his stack.
Well, you need to write that in there for each one. Okay, and I will sign it. Okay. All right. Carlos Martinez.
I'm present on him again. Unfortunately, he has not had an event.
All right. Court is calling 2017 CR 7730, State of Texas versus Carlos Martinez. Could our parties announce for the record for the state,
Ryan Grover for the state.
for the defense?
Brandon Lopez from Mr. Martinez.
Oh, this one's done. And off the record for a moment, Ms. Ferguson, can one of you all see if he's on PR bond or not? All right. This hearing was scheduled, we're back on the record. This hearing, it was scheduled at 9 a.m. and is now 10:39 a.m. Defendant has not made appearance. Counsel, have you had a chance to contact your client?
Your Honor, we haven't had contact today. We did have contact yesterday. We'll continue to try, but at this point, we don't know where he's at.
All right. And so Deputy Laura has informed me that the defendant was not in the hallway as well. Oh, there's been no bond set for him.
Right, because I think he was in INS custody for about a year and then he was released.
All right, so he doesn't have a bond set.
Does he have a warrant for his arrest?
He didn't have a warrant to this point.
He does have a warrant. All right, so I'll put him down as a no-show. He doesn't have a bond set, so as soon as he's taken into custody, then we will come back.
Does he have a warrant?
Oh, he doesn't?
Yeah.
All right, the court will ask that a warrant be issued.
Your Honor, if I make contact with him, can I approach about setting a bond?
Yes,
Thank you, Your Honor.
you're welcome. Okay, oh, yes, I remember this. Are they here today? Okay. Well, she needs to be taken into custody. Okay. All right, who's here on Rosalie Morales? All right, what is happening with this case, counsel?
Judge, I believe the defense has provided me some mitigation stuff. It is a case, it has some, I guess it's a little involved. So I told him if he can get a 30-day reset, I'll review the mitigation stuff and get him an offer by next day.
All right, Ms. Ferguson, can I have this case recalled for 30 days, please? All right, we'll be back on November 4th.
Thank you, Judge.
Erica Lopez. All right, counselor, what is happening with this case?
I conferred this morning, Your Honor, with Mr. Sanders, and I believe his office wants to do a little bit more investigation, so.
Yes, Judge. The victim in this case is a Spanish speaker, so I asked for just a short recess so we can try to get in contact with her.
All right, how much time are you requesting?
2 weeks.
All right, Ms. Fergus, can I have a 2-week reset for Erica Lopez? All right, Ms. Lopez, are you employed?
Yes, Your Honor.
Are you having to take off work to come down? All right, so if you wish, I'll let you appear by Zoom because I know you were here previously on September 26th, and we recalled it for today. But here's the thing, when you appear by Zoom, what that means is you can be at your job, but you need to let them know that you need to take a break because I require that people, if you're on Zoom, you're professional on Zoom, okay? All right, so Ms. Fergus, will you note that the defendant can appear by Zoom, please? All right, they'll give you a reset form. Oh, no, I turned that back in. Yes, I think so. Okay, who's here on Sky Daniels?
She left. Judge.
Who's here on Zinnia Para? All right, if I could have parties approach. Court is calling 2022 CR 6829, State of Texas versus Zinnia Para. Could I have parties announced for the record for the state,
Ryan Groomer for the state.
for the defense?
Tim Ratchford from Ms. Para.
All right, and are you Ms. Para?
Yes, sir.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Judge.
Court will find that the state is in compliance with discovery. Ms. Para, I'm showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it and did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we'd make a motion to proceed on the lesser included offense of Class B misdemeanor DWI.
Any objection?
No, Your Honor.
Ms. Parr, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? Right. Did you understand the state is proceeding on the lesser included offense of driving while intoxicated as a Class B misdemeanor? The range of punishment for that offense is up to 180 days in jail and up to a $2,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Judge.
Ms. Parra, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I did.
According to the plea bargain agreement, the state is proceeding on Class B misdemeanor DWI. Punishment is be assessed at 180 days in the Bexar County Jail. There's a $500 fine. There's no application for deferred adjudication. State is recommending community supervision. There's to be ignition interlock for the full term. DWI intervention, 1-year Texas driver's license suspension, the DIP live parenting classes in DWI education. Did you understand that to be the plea? Defense,
Yes, Your Honor.
state?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargaining agreement. State is requesting that your community supervision be for a term of 2 years. There'll be a top evaluation and 80 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, I did.
Then to DWI is a class B misdemeanor. How do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. State would offer state's exhibit number 1.
No objection.
Ms. Parham, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. At reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, just asking to follow the plea agreement. Spara is very remorseful over that. It was a really bad circumstance for her, but it's not an excuse. And she's going to do better.
All right, so Ms. Parr, how old were your children?
I have a 4-year-old and a 2-year-old.
All right, so something bad happens in your life, so you decide to drink and drive with 2 young children in the car. Do you even understand what could have happened? And what I've discovered, and again, my statistics professor would be disappointed in me for saying this, but this is just what I've discovered. What I've discovered is people who drive intoxicated, you know what ends up happening when they have an accident? They're just fine. They walk away without a scrape. Usually the person who ends up getting killed is the passenger or somebody that they hit, just the person who's trying to go to a lunch date or dinner, they get hit and the drunk driver is okay. And then they come in boo-hooing and crying. So your husband, according to this, was unfaithful. So you decide to drink and have your 2 children in a vehicle while you're drunk. And I read the police report. So what ends up happening, you get arrested and the husband who you said was cheating on you comes and picks up the children. So are you still in a relationship with him?
I'm still married to him. Yes.
And you're working on things?
That's right.
See, here's the thing. In relationships, you have choices to make. And I guess your choice is to stay with him. But in a relationship, when you have children, and people may disagree with me on saying this because I don't have any children, but what I do know is 2-year-old and 4-year-old can't make decisions on their own. And so in relationships, when you have children and those children can't support themselves and be on their own, you should be putting them first. And putting them first was not driving with them. You understand?
If I may say something.
Yes. Sure.
Okay.
Yes.
I just wanted to say, like, this is not an excuse. I own up to what I did. But my mother had also passed away that same year.
Mhm.
So it was a lot of other things that occurred throughout that time. It wasn't just my husband cheating. So I just wanted to say that.
Okay. How old are you?
I'm 34 years old.
All right, so here's the thing, people who want to drink, you should not drive. If people are feeling depressed and they want to drink, go to your house, drink at home, have a babysitter for your children, take a mental health day, find some adult who is responsible to take care of your children, and you can drink and walk, although I don't recommend that because you'll probably cause an accident by walking in the street. You can drink and ride your bicycle, although I don't recommend that. You can drink and take the via bus, but of course you'll be charged with public intoxication. You want to drink in your house and cry, go ahead. I found what really works is just take a bubble bath, cry away in the bubble bath, eat some chocolate, drink some water, and the day will look better. The next day is always better. And you almost had a permanent solution for a temporary problem. So your temporary problem was your husband's cheating and you get in the car with your children. And if your children would have died, you would have been losing your mind and you would have been charged with something different. And I need you to understand that there is never any excuse, no matter what is happening in your life, for somebody to get behind the wheel of a car and they've been drinking. Because then guess what? Your problem, your bad day becomes somebody else's bad day and problem if you hit them. And who knows, your children may end up finding a cure for cancer and that would have been removed for us because of your actions. So I'm hoping that you truly understand your actions and truly understand what could have happened and where you could be. You understand? So are you receiving any type of therapy or mental health treatment for all of this that has been dumped on you?
I guess God is my therapy. Really, is my therapy. That's what I call therapy to me.
Okay. All right. And I'm going to give you some relationship advice. What people should know about relationships. If you get back together, whatever problem existed before you got back together, if it is not addressed and solved, it's still there. You just back together. You understand? All right. This is what the court is going to do. The court is going to sentence you to 180 days in the Bexar County Jail. That'll be suspended and probated for 2 years. There's to be ignition interlock full term, DWI intervention, 1 year Texas driver's license suspension, DIP live, DWI education. There's to be 80 hours of community service restitution. 40 of those hours will be waived. If you provide proof of the COVID vaccination, the court is not requiring you to do that, but if you do, 40 of those hours will be waived. There's to be parenting classes. And once you complete those parenting classes, the remaining hours will be waived. Are you employed?
No, I'm a stay-at-home mother.
All right. There's to be regular reporting by Zoom or in person. There's to be field visits 1 time per month. And probation, let them know when they do the field visits, they need to look in the refrigerator and everywhere else to make sure there's no alcohol in the house. There's to be regular UAs. And make sure she's tested for alcohol. All right, is there anything else you need from the court? Probation, is there anything else she needs?
Your Honor, I believe the DIP live is supposed to be VIP live.
Okay, thank you.
not DI.
All righty. Well, I thought maybe you were planning on dipping in, dipping out. Okay.
Nothing else, Your Honor.
All right. Anything else with regards to sentencing? All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck. We can go off the record. So Ms. Parra, here's the thing. It sounds to me like your day is occupied. You take care of your children. You stay at home, take care of the house. What do you do outside of that? Do you have friends? Do you have hobbies?
I do have hobbies. I like to exercise, so I like to play with my children outdoors.
Okay, exercise is not really a hobby. That's a lot of work. Yeah.
I like to read. I like to write poems.
All right, so here's the thing, and I don't know what is happening in your marriage. I hope it is successful and everything works out. But I always tell people, I think stay-at-home moms are great. I think it's great for children if you can stay at home. Not everybody can, but you need to be able to support yourself. I'm not ordering you to get employment, but if your marriage were to end today, it's sort of like how the bill's going to get paid, what's going to be done. So you need to make sure that you're able to support yourself. You understand? All right, good luck to you. You're welcome. Who's here on Corwin Campbell?
Morning.
Good morning. And let me see where Mr. Campbell is. Thank you. All right, what's happening with Mr. Campbell's case?
You should have two documents in front of you, a defendant's pretrial motion and a defendant's second amended discovery motion is what we'd like to address today.
All right, I should. Let me see if I have it. When was that filed?
The first one was filed. The pretrial motion was filed
Yes.
on August 18th. The second amended discovery was filed yesterday at 8:04 a.m.
All right, so I don't have any of the motions he wants heard.
No, we've already addressed that one.
Okay, if you just, and if you want, if they're not in the system, he can give you copies and we can make.
Well, yeah, they have my notes on it, but that's okay.
Oh, well, no, because I need a clean copy. They'll get one.
All right.
All right. Mark Lewis. Mark Lewis.
He's in the box here. President.
Hello. It's good to see you back. I know you came back from your classes, and how did your presentation go?
Very well, Your Honor. Thank you for asking.
Oh, you're welcome. All right, so where are we on this case?
Judge, I was successful in getting a PR bond granted in the misdemeanor court, and I was going to ask the court consider a PR bond with GPS full monitoring and Hager and Hope.
All right, so the question would be, where is the PR bond evaluation? Because I would need to see that in order to make a decision. Ms. Ferguson, do you know if there's a PR bond evaluation on this case from the misdemeanor that I could look at? All right, so if you'll just have a seat and we'll see if we can find that. Yes. Sergio Martinez. Sergio Martinez. Oh. Oh, okay. Is he in custody or no? No. Can you let him know? We're going to recall his case for October 3rd, that his attorney is in jury trial in the 290th. All right. Is there someone here for Sergio Martinez? Is there anyone in the audience for Sergio Martinez? Okay. Thank you. Now they have all that beeping because they're working on the sound system. I want to see that translated to actually working when we're in trial. We shall see. Oh. Oh. Oh, I'm so sorry. Well, I hope everything's working. Okay, awesome. Thank you. Oh, no, no problem. That's fine. We want to make sure that's working, okay? Oh, no, there's no need to apologize. We just thought it was something else, but now we know. All right. And now if I don't hear that sound, I'm going to think something's wrong. So we will rush to you, to your aid, okay? Oh, you're welcome. Yes. Sure. Thank you. Mark Lewis. Mark Lewis. Okay, thank you. Robert Trevino. All right, so actually we're here, it says we're here on discovery.
That's correct, Judge.
So where are we on that?
I've received all the police reports that I've asked for at this point, Judge. The state today has made an offer, and I would request a reset so that I can consider that offer with my client.
And what date are your other cases set?
November 4th.
All right, Ms. Ferguson, are we able to call Mr. Trevino back on November 4th? All right, so November 4th would be your plea deadline date. After that, the court would not accept any offers without good cause. Do you understand? All right, let me see what page he is on. Thank you. All right, so just get a reset form and we'll be back on November 4th.
Thank you, Judge.
All right, thank you. You're still getting sleep or not sleep?
Yesterday was actually kind of rough.
Yeah.
Or I guess today, this morning.
Yeah,
Yeah,
it'll get better.
yeah,
Just think when she gets older, you're gonna say, please need me.
I know.
Yeah.
We're touring a daycare this afternoon, so that's kind of nerve wracking.
Oh, my gosh.
That's in the future.
Make sure there are cameras.
I know, right?
Yeah.
Yeah.
All right, thank
All
you.
right, thank you, Judge.
You're welcome. Gilbert of Corta.
Morning, Judge.
Good morning. Mr. Corta, please come forward. And let me just find him on the docket sheet. See how I look over to my left? Let me just, Gilbert or Corta. All right, thank you. I still will not change my glasses, so. All right, so what is happening with this case?
They made their initial offer to us, and it's contingent on us working out an agreement for the DWI, which is set the 26th of October.
Okay,
And we don't have an offer on that one just yet.
all right, so that case is going to be worked out on the 26th of October?
We don't have an offer yet. We hope so. We believe so. If we can get this one recalled to November 4th, that'd be great.
We're going to recall this. You said October 26th?
That is correct.
All right, Ms. Ferguson? Can we set this on October 27th? All right, so we're going to come back on October 27th. And of course, if everything's worked out below, then you won't have to come on that date. But otherwise, we'll see you here.
The deal it isn't one of those where this one will go away, Judge. It would be a deal where he also pleads on this one.
So then Norman, not the 27th. Can we put it on the 26th? And we'll just, I'll note that he's going to be late. So take care of the county court case first. All right, so we'll see you back on October 26th.
Thank you.
Thank you, Ms. Ferguson. We'll give you a reset form. All right, who's here on Darrell Lewis?
I'm here.
Okay. Yes. Court is calling 2022 CR 2460 State of Texas versus Darrell Lewis. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Good morning, Judge. Dirk Ashball for Mr. Lewis. We're ready.
And are you Mr. Lewis?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Lewis, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Judge, we are waiving the receipt enhancement paragraph.
Any objection?
No objection, Your Honor.
All right, Mr. Lewis, I'm going to show you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am. Indeed.
Did you understand you're charged with the offense of theft under $2,500 enhanced as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Judge, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, I do.
Mr. Lewis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is asking that your punishment be assessed at 30 days in the Bexar County Jail under 12.44 of the Penal Code. There are no applications. This will run concurrent with 692212. They will take in consideration 671430. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, state offer states exhibit 1 and its attachments.
No objection, Judge.
Mr. Lewis, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, I just ask that you follow the plea agreement.
All right, Mr. Lewis, what's going on with your life? Because you keep stealing.
Depression.
Hmm?
Just hard-headed and ignorant.
Well, no, here's the thing. How old are you?
I'll be 55 in November.
All right, November what?
29.
All right, so here's the thing. You're at a point in your life where more of your life is behind you than in front of you. I can say that because more of my life is behind me than in front of me, unless I'm planning on living to be over 100. Do I want to live to be over 100? I don't know. We'll see how it goes. You are spending a majority of your life in custody, either at the Bexar County Jail, at a state jail facility, or at the prison. If you don't change your ways, you're going to find yourself spending more and more time of your life in prison or in jail. Now, today, the state and your counsel have come to an agreement where you go to the Bexar County Jail, and I'm sure this is supposed to be a judgment satisfied. Am I correct?
Yes, Judge.
Now, what you need to realize is that this case, really, you could have received more punishment if the state were to proceed on the repeat enhancement allegation paragraph. And even though this is being, if I follow it, even though this is a misdemeanor punishment, it's still a felony.
Yes, ma'am.
And so it can all be used to enhance. And when you come back, which I hope you don't, but if you were to come back, it may be another attorney, another prosecutor, and you may end up doing serious jail time. I'm going to tell you, in my career, there was a gentleman who was on parole for life. And I'm reading the documents trying to figure out, okay, why is this guy on parole for life? And you know what it was for? Do you know on the water hose, those little screws that you have on the end that cost like, they're probably like 50 cents now. I think at the time they were like 10 cents. That's what he's doing life for parole for that little thing that goes around the water hose. You know why? Because His record was riddled with a bunch of thefts. So you don't want to be the person who's at the prison when they ask you what you're here for. And it's like, I'm here for stealing a razor. I'm here for stealing body spray. Do you have employment?
Not at the moment, but I will,
Did you have employment when you did this?
not at the time.
All right, so here's the thing. There are so many places that are free that will help you. You can go to the Salvation Army, you can go to Haven for Hope, you can go to different places. They have food banks, so you can get food. You don't have to steal that. And I guarantee you, some stores, if you walk in and say, look, this is what I'm going through. Could I have some food? They're going to do one or two things. Either they're going to say, yes, we will give you some food, or either they're going to say, no, get off our property. And if they say, no, get off the property, then you get off the property and you go to the next store. And there's always somebody willing to buy somebody a sandwich. You understand? Do you have any family here?
I have 4 sisters here. And I have 3 sisters here.
Mhm.
Parents are dead. Brother, I had a brother got killed about a year ago.
All right, so here's my thing with your family here. Are your sisters, are you in contact with your sisters?
Mhm.
Do they have homes and places to stay? Are they stealing?
You know, since I'm the baby, they giving it to me 100. They just.
See, so here's the thing. You've got to stop being the baby. You're now a grown man.
Yes, ma'am.
All right. I don't want to see you back here again or see you at the prison. You understand?
Yes, ma'am.
All right. The court is finding you guilty. The court will sentence you to 30 days in the Bexar County Jail under 1244. Give you credit for any time served. This is run concurrent with 692212. Take in consideration 67143. And the court will show that the judgment is satisfied. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Know better, do better. You can't be the baby of the family forever.
No, ma'am. Thank you so much.
Thank you, Judge.
All right, you're welcome. Who's here on Stephen Ward?
Morning, Judge.
Good morning. So if you could slide. All right, there, Stephen Ward, what is happening with this case?
Judge, I reviewed the file yesterday. We've previously requested, since we have a lot of medical records on this case, but particularly of importance is Methodist. We requested these back in December of last year. It looks like this is the first setting, so it's the first time I'm reviewing it. Looks like those haven't come in yet, so I'm letting Marina know that we need to issue another subpoena to have those come in. Also, in reviewing the case, I've already made Mr. Acevedo aware that we might be re-indicting. It's not going to be an upgrade or reduction in the charge. It's just how it's currently alleged. I believe that it could be much better.
Okay. All right, Ms. Ferguson, can I have a 30-day reset on Ward for discovery? Yes. All right, we will come back on November 3rd. And with regards to Mr. Ward's conditions of bond, is there no contact with minors in that? Or no unsupervised contact with minors? And is Child Protective Services involved?
They are, Your Honor, and right now they have supervised visitation.
Joseph, how you been doing?
Hanging in there, Your Honor. Hanging in there.
Okay.
Thank you for asking.
It's like I haven't seen you in a while. For a while, I was seeing you every day, especially on Zoom. Now I'm like, where is he? All right,
That I see, was in August, and there was order of no contact just with the child in the indictment.
all right. The court is going to do no unsupervised contact with minors in addition to the current order. And you say the current order is no contact?
That's what I see, Judge, as of August 22nd, 2022.
We would ask that the court would consider allowing him supervised visitation through CPS as was being done prior to this charge and the no contact with, he hasn't had any contact since posting this bond.
All right, so what we'll do is we can have a hearing on that as far as that is concerned. For now, it's no contact, but you can ask for a hearing on that and have the CPS caseworker zoom in. And who's the child's attorney?
I don't have that. We noticed, we spoke to the CPS representative, caseworker. And she was made aware of the condition. We actually sent her the conditions on 8/25 and she hasn't reached out since.
All right, could I have a B page on this case? It's 2022 CR 7666. And so, Mr. Ward, there's to be no unsupervised contact with any minor. And your current conditions are, there's to be no contact with the complainant. So we'll need to have a hearing on that. And Mr. Acevedo, you can set that and we will make sure that the caseworker make sure that the caseworker is here and the child's attorney if possible.
Yes, ma'am.
All right, is there anything else?
No, Your Honor.
Thank you.
May we be excused, Your Honor?
Yes.
Thank you.
Thank you. Yes.
Did you sign the CPS order?
Oh, let me see. Thank you. Yes.
Okay, I'll get those into John Acevedo. ASAP.
Thank you. Trey Dion Johnson.
Here you are.
All right, the court has the discovery acknowledgement. All right, and has the state made an offer?
They have, Judge.
Ms. Ferguson, can I have a 33-day reset for a plea deadline date on Mr. Johnson? All right. So, Mr. Johnson, your plea deadline date will be November 3rd. After that, the court will not consider any plea bargain agreements without good cause. Do you understand? All right. Do you have any questions? You seem sort of quizzical.
That's a separate issue.
Okay. And let me see what page he is on. Thank you. All right, Ms. Ferguson, we'll give you a reset form.
Thank you, Judge.
You're welcome. Narand Alexander. Narand Alexander. Well, it's always great to see you, although I see you every day.
That's right. Good to be here, Judge.
All right. So where are we on this case?
We are still in the discovery part. I just found out from defense that they have not seen uploaded discovery. So I'm gonna be going upstairs this afternoon and figuring out why they're unable to access or see it. And so we're gonna get that worked out and they're gonna have full discovery and an offer next week on the case. And we've been conferring throughout the course of the morning on the evidence, and I've been briefing Mr. Contreras on basically what is in the file and the facts of the case and all of that. So we've still done work this morning.
Okay. All right. And Mr. Alexander, thank you for dressing appropriately for court. All right. See, I try to tell people sometimes you don't have to wear the suit and tie every day, just, you know. All right, Ms. Ferguson, can I have a 30-day reset for discovery? All right, we're going to come back on November 3rd. If you all want to come back sooner, just let the court know. And Ms. Ferguson will put you on the docket sooner. So on November 3rd, my understanding, all the discovery will be tendered and states you'll be prepared to make an offer.
Yes.
All right. Thank you.
Thank you, Judge.
And counsel, Ms. Ferguson, will give you all the reset form. Mr. Alexander, you need to wait till you get the reset form. Okay, here. Who's here on Ventura? Vincent Ventura? Vincent Ventura. I thought this was already done. Oh, okay. Well, as soon as she comes back, we'll take the matter. Yeah. Corwin Campbell.
On the record.
I will call it on the record, counselor. Just take your positions. Everybody stay in your lane. If everybody stays in their lane, the court will go just smoothly. All right.
I think Marcus was looking at this one, right, Mike?
Oh, yeah.
All right. I
Okay.
think he might have stepped out right here.
All right.
I don't know exactly what the hearing's about.
Okay, we'll take that up when he comes back. Sky Daniels. All right. What is happening on Sky Daniels?
Like a trial setting.
All right. All right. Do you have all the discovery?
I do, Your Honor.
Was an offer tender?
Yes, it was, Judge.
And was that tendered today?
It was, Judge.
All right, Ms. Ferguson, can you recall this back in 2 weeks for a plea deadline date, please?
We want to be set for trial now, Judge.
You're coming back in 2 weeks for a plea deadline date. And Mr. Daniels, you're to let the court know whether or not you're accepting the plea at that time. And then you will be given a trial setting if you choose not to. All right, we're coming back on October 14th.
I know you're rejecting the plea, but she won't let you do it today.
All right, Mark Lewis. And Norman, you said on this one, we did have the report. That's good. All right. State on Mark Lewis, they're requesting a PR bond in this case. Have you had a chance to review the application that was filed in misdemeanor court?
No, Your Honor.
Yes, please. Oh.
Yeah, he's supposed to sign it. He's gonna take it without signing it.
Mr. Smith? From reviewing the PSI report, I'm not inclined, of course, I would keep an open mind, but I'm not inclined to grant him a PR bond based upon his criminal history. Have you had a chance to review it?
We have.
So I'm not sure if there's anything else that you would be requesting.
Your Honor, maybe a lowering, I believe the state's initial recommendation was 8,000. Instead of 15.
Okay, well, we may need to file a motion to have a hearing on that because I'm looking at the PR bond evaluation that was done. And his criminal history is not one that I would consider giving a PR bond to.
I understand, Your Honor.
So if you file a motion for a bond reduction, if you guys can't agree on one, then just file a motion and I'll hear that. And Mr. Lewis, I'll hear that as quickly as possible.
Smith.
All right. So have you received all the discovery, Mr. Smith?
Yes, Your Honor.
Was an offer tender?
There was, and we were unable to resolve the issue as of today.
All right, Ms. Ferguson, can we have a 2-week reset on Mr. Lewis for a plea deadline date? So we're gonna come back on October 14th, and if you would like to file your motion and have your bond motion heard on that day as well, we can do that as well.
Very well, Your Honor. Thank you.
You're welcome. Who's here on Kavan Rangel?
I am, Your Honor.
All right, what is happening with this case? And I know you were recently, I think, placed on the case. Is that correct?
Yes, Your Honor. A couple of weeks ago, I did get a lot of the discovery. There's still some missing as far as medicals are concerned. I've gone over some of them with Mr. Rangel. The state has needs to review some more stuff before they can make me an offer.
I'm going through it. I can make the report an offer, I believe, the next setting. The medical records that he's referring to, I'm trying to figure out if we have them or not. I'm saying an email to see if we have them in the office. If not, to try to see how long it'll take.
All right, is the medical record for the aggravated case?
The aggravated is going to be the one that's driving the question.
Okay. All right, how much time are you all asking for?
30 days, Judge. At least we can come back and find out where we are. I saw we did subpoena the medical records. I just don't have them, and I have no notice that nothing indicating we've gotten them back. So I want to try to figure out where they are.
All right, Ms. Ferguson, can I have a 30-day reset on Rangel?
November 3rd.
All right, we'll be back on November 3rd.
Thank you, Judge.
You're welcome. Vincent Ventura.
Good morning.
Good morning. All right, the court is calling 2020 CR 2642, State of Texas versus Vincent Ventura. Can I have a parties approach and announce for the record for the state,
Marcus Sanders.
for the defense?
Jody Sawyers.
All right, so this hearing was scheduled at 9 a.m. and it's now 11:44 a.m. Defense, do you know where your client is?
Your Honor, we have not been able to maintain contact with him. He failed to appear at the last setting that we had. In your court, you issued a warrant. I did communicate that a warrant had been issued and that we would be withdrawing. And the same day that you issued the warrant, and he has not contacted us back regarding that issue, although we can see that he received our communication because it's logged on our client portal.
All right, Deputy Laura, is Vincent Ventura outside? Vincent Ventura. Did he announce?
There's no one in the hall, Your Honor.
All right. And Ms. Ferguson, does it show that he has a judge's warrant in the system?
So warrant, there's none on the night mag, and I thought I saw one on the indicted.
There's a judge's warrant on this. Okay.
He has a nightmare? Oh, the one
You're
that,
not on.
okay, I was like,
All right, I want to make sure that's a judge's warrant on this case. All right. All right, so next we have defense has filed a motion to withdraw. State, any objection?
No, Your Honor.
All right, then your motion to withdraw is granted.
thank you, Your Honor.
You're welcome. Who's here on Armstrong? Logan Armstrong. Let me see what page we're on here. Thank you. Logan Armstrong. Oh, yep, I see there. All right, why were you late for court? Okay, you need to speak up. How old are you? All right, so you're old enough to get your own ride. And guess what? The person who you're waiting for to give you a ride, they are not the person who needs to be here. So if you're late again, what's going to end up happening is the court will give you transportation, and that transportation will be from the Bexar County Jail. You'll be brought over in a blue uniform or red uniform or whatever classification they give you. You understand? So you need to make your own plans to make sure that you're here in court on time. Counsel, where are we on this case?
This is our first setting on the case. We've been given an offer. I've discussed it briefly with my client, and I would like a date for a final plea date for her.
You have all the discovery?
I believe I do have all the discovery on it, yes.
All right, Ms. Ferguson, can we have a 30-day reset for a plea deadline date? All right, your plea deadline date is November 3rd. I'm making a notation that you were late for court. Do not be late for court on November 3rd. Do you understand? All right, Ms. Ferguson, we'll give you a reset form and then you are excused.
Thank you.
You're welcome. All right. We'll take up Corin Campbell, counsel, as soon as you finished with your client in the reset form. All right, the court is calling 2022 CR 4368, State of Texas versus Corin Campbell. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Mike Latimer.
And are you Mr. Campbell?
Yes, ma'am.
All right, we're here for discovery. Let's begin with the motion that's entitled Defendant's Pretrial Motion. State, do you have a copy of that?
Yes, Your Honor.
All right. So I'm going to go to the page that is the order. And let's go number by number. State, are you in agreement to item number 1?
Yes, Your Honor.
Number 2,
Yes.
number 3?
No.
And what is your reason for not agreeing to that?
That is too broad, Your Honor.
How so?
He's asking for all handwritten or typed notes of any police officer or other law enforcement agent who investigated and or participated in any manner in this case. I essentially, I guess, the participated part. That could be, I mean, it could be an officer who was there for cover or for like traffic control. And if they have any notes, he's asking for that, even though it has nothing, because technically they would have participated in the case, but it has nothing. to do
Well,
with
I mean, if the
actual-
person is there for traffic control, would they have made a note saying that I'm here for traffic control? Or would they not have made any notes?
I'm not sure, Your Honor.
Okay, I'm not sure why I shouldn't grant him access to officers' notes if they have notes related to this case. Because the person who's working traffic control may say, by the way, I saw this guy in a green shirt who walked by who looked odd or out of place. So I just don't see that as being overly broad. And you're objecting to the word participated.
Yes.
What would you like the word to say?
Well, I think that just any law enforcement agent who investigated in the case or who investigated the manner of the case
Okay,
would cover any concerns.
defense?
Your Honor, detectives are involved in cases who may ask other officers to do something. That would be participation. There are at least 2 detectives on this case that were involved in this case, and at least 3 other officers that were involved in this case. Not sure what exactly they may or may not have done.
How many officers were involved in this case total?
I believe 5 or 6.
Okay, so 5 or 6 officers involved in this case total. Is that correct?
I'm not sure, Your Honor.
All right, so does anybody have a list of the names of the officers involved? And the court will order that those officers provide whatever notes they took. And then that narrows it to those officers.
But what if there is nothing identified in the DA's file regarding an officer that may have been asked by Detective Martinez or Detective Voltieri to do something, and that officer may not have been identified in, for example, Detective Martinez's prosecution guide to do something after the events of this day of September 13th.
Okay, so you all just told me that there were 5 officers, 5 to 6 officers
listed.
involved.
Yes, that are listed. I didn't want, if I put just the officer's name.
No,
on
I
there,
understand that.
That would be a problem for me if we later learned, could be years down the line, that there was an officer that prepared some document related to this case. this whole case has to deal with identity.
Mhm.
I mean, if I could give you a brief scenario of what the issue, what the facts are that I've seen so far in the DA's office, it wouldn't take very long dealing with identity. I can start with the 911 call. 911 call, the victim says, I was shot by an AR with a black male in a black car. Man was 30, 40, or 30 to 40.
All right,
years
3
of
will be granted. Next.
age.
We agree, Judge, on 4.
5.
We don't agree, Judge.
Why not?
Because I'm not sure what defense is asking, and I believe the wording would lead to. So it says, including any contradictory statements which tend to impeach the credibility of any state witness. It doesn't say as it relates to this case, and so, or like I understand criminal history, but I believe this wording would allow like any lie that they ever told in their life, that we would have some sort of duty to provide info on it, the way that is currently written.
All right, defense.
Your Honor, I hate wasting judicial time.
Oh, it's not a waste. That's what I'm here for.
I mean, I filed this on August 18th. If the state wanted any clarification, I would have been.
But here's the thing, it doesn't matter, as my grandmother would say, doesn't matter. We are here now. So I'm here. I'm willing to go over it. So
That's limited to this state case. Any exculpatory statements from any witness that's related to this case.
state,
No objection, Judge.
okay. Okay, and I'm going to add related to the instant case because that's what you all have put on the record. And that's agreed. Number 6,
Agreed.
number 7,
Agreed.
8,
I don't agree.
and why not?
Judge, this is essentially asking us to, I guess, provide our trial strategy before we do it. Sometimes we think of exhibits or maps or something that we may want to use after the point. Obviously, we will provide everything that's in the police file and everything that's in our file, but this encompasses anything that we could potentially think to use at trial.
This does appear the way it's worded to encompass work product. So for example, if the state wanted to use a chart to say these are the elements of the offense, then you're asking to get a copy of the chart that they're going to use.
Yeah, I'm not seeking that. So I'll limit it to the images of the defendant, images of the location of the incident.
We would object to that also.
Wait, images of the defendant, that's going to be allowed. And you want images of what?
The location, if they take photos of where this shooting took place.
Okay, do y'all have photos of the location, like the evidence? Because he's asking for photographs of the location. I don't know anything about this case because no evidence has been presented to me, but it seems that the defense wants crime photos. If you have them, if somebody took a photo of where I guess evidence was found, he wants those as well. So I don't understand why the state is opposed to that.
Same thing, Judge. We sometimes have cases where we go out and take photos like days before the trial. And of course, there may be issues getting it in, but like, again, I think that that would be like work product that we produce for trial and not.
Well, how about this, that it says, instead of that the state intends to use during trial, that was tendered to the state? Counsel, are you okay with that? Tendered to the state by law enforcement defense?
It's fine.
By law enforcement. State, are you in agreement?
Yes, Your Honor.
All right, the next is 9,
No objection.
10,
Agreed.
11,
Agreed.
12.
Judge, partial agreement. The CAT system, I'm not sure if that's something that we can provide. I know it's the computer system that the officers use. So I guess first, my concern is that there may not be something that can be printed out. And second, because it involves law enforcement, I'm not sure if it's something that we can provide without a court order or.
All right, so this is what we'll do. So there's an agreement to the incident detail report. We will have another setting on the computer automated dispatch and see specifically what you're requesting, counsel. If it's a printout,
Well.
then we'll see if we can get a printout.
I'm not seeking that. That only deals with a case that's handled by the Bear County Sheriff.
All right, so you
That's
do not
where I
want
put
that?
in. Yes, I don't need that.
All
It's the
right.
Incident detail.
All right, so the court is removing from your document the request for the computer automated dispatch, and you only want the incident detail report from SAPD?
Yes.
State,
Agreed, Judge.
13,
Agreed.
14,
Judge,
He abandoned that.
okay. So that's withdrawn by defense. 15,
I believe, Judge, we clarified that he's asking for the IDRs and the calls for service, and we are agreed to that if that's what he's asking for.
is that what you're asking
I
for?
want all 911 calls that were associated with this shooting on September 13, 2021.
So he wants the 911 calls.
So that would be number 13, Judge, and so we agree to that if that's what he's asking.
That's fine.
All right, so are you withdrawing 15?
Yes.
All right, 15 is withdrawn by defense. 16,
I couldn't understand what he's asking for in this one, Judge, so I said not agreed.
all right, what are you requesting?
This case it deals with a shooting that was identified by the victim on a 911 call. The suspect vehicle was a dark four-door sedan, later identified as a black Audi.
All right, so what do you mean by all inventories?
Well, if they made a search of that car, because they knew knew where the car was. So I want to know if any searches of that car was done.
So you want, then you don't want all inventories, you want,
Just want anything associated with any search of that vehicle or any other search that law enforcement conducted on this case.
all right, now I see what he's requesting. So he wants documents related to any searches conducted by law enforcement, is that correct?
Yes.
So that's all you want, the documents? Defense, I'm sorry, state,
Agreed, Judge, to that.
all right, and so I'll change that to all documents secured by law enforcement as a result of searches conducted by law enforcement.
Yes.
All right, number 17.
Withdrawn.
Okay. 17 is withdrawn by defense. 18,
Agreed.
19,
Agreed.
20,
Agreed.
21.
Withdrawn.
21 is withdrawn by defense. 22,
I didn't understand 22, Judge.
all right, defense, what are you asking for in 22?
Well, this is right from the Court of Criminal Appeals decision of Watkins versus State, and that was the actual wording of the motion that was presented on that trial. in
So what
which
are you asking for?
Any material that's involved in this case.
All right, so whatever evidence you
Any
have,
material.
defense is wanting it.
Yes, Judge, agreed.
Okay. 23,
Agreed.
24.
Withdrawn.
All right, 24th was withdrawn by defense. 25,
Withdrawn.
okay, 25 is withdrawn by defense. 26. Basically, that's if there is some sort of IA or some issues with an officer, which I think the state does keep a list of, at least they kept a list of that when I was in the office.
Yes, Judge, we can't provide the list, but we definitely would provide any Brady memos that we have. And I don't know if that's all that he's asking for.
Defense,
Yes, if you have a list.
No, we can't provide the list.
Oh, not the entire list. It'll be whoever is related to this case.
Yes, right.
Is that correct, State?
Yes, we will provide a memo on anyone who is on the list in regards to this case.
Yes.
Okay,
That's
whether
what it says in here, involved
this
in this
case.
case.
All right, so he's asking for the list of officers who are on this specific case, not your entire list. So if you have someone who has a credibility issue, that's an officer that's in this case, he wants to know about that.
Yes, Judge.
Okay, so that's agreed.
Yes.
27.
Withdrawn.
All right, 27 is withdrawn by defense. 28.
Withdrawn.
28 is withdrawn by defense. 29.
Withdrawn.
29 is withdrawn by defense. 30.
Withdrawn.
30 is withdrawn by defense. And in the court's copies, 31, 32, and 33 have been removed. Is that correct, counsel? 34.
Withdrawn.
34 is withdrawn by defense. 35.
That is the statement, Your Honor, that's a post. Usually, and I haven't seen it in this case, it may have been produced, it's this, it's the affirmation by the law enforcement officer that they have provided all materials, including Brady.
All right, do you have that?
I will check, Judge. We have no objection if that's what he's asking for.
All right, that'll be agreed. 36.
We object to that one, Judge.
Okay, I don't understand the objection. Did somebody else talk?
Well, Judge, he's asking for the dates. He's not asking for any specific document or item. He's asking.
Oh, are you asking for the specific
I'm
date?
asking for the documents. I put a note here. I'm asking for the document. After May 9th, 2022, that's his indictment date. That occurred in September of 2021. He was indicted on 9/2022.
All right, so to make it clear, we're going to remove the words dates. It's going to say after May 9th, 2022, defense is requesting that any law enforcement officer and employee or person acting on behalf of the San Antonio Police Department spoke to the persons that are listed and any other witness to the incident of September 13th, 2021 be provided. Any objection?
So for any documents or audio statements?
Yes.
Okay, because those were learned in here, so I'm making sure. Yes, no objection to that, Judge. If we add those words in.
So let me make sure I have this worded right. And I'm going to add be provided. Are both parties agree to that?
Yes, sir.
Yes, Your Honor.
37.
Judge, I object to this one.
That'll be denied. Counsel, my understanding is that all of the documents are going to be provided to you, and that's something that can be handled on cross-examination.
Okay, so will you be ordering them to produce those documents?
My understanding is that throughout your motions, they have already said that they're going to produce every document that they have. Is that correct?
Yes, Your Honor.
So what you do with those documents that are produced to you will be up to you on cross-examination. Number 38.
That's withdrawn.
I'm sorry?
That's
Withdrawn. Number 38 is withdrawn?
Yes.
All right, 38 is withdrawn by defense. 39.
Withdrawn.
39 is withdrawn by defense. 40.
Withdrawn.
40 is withdrawn by defense. 41.
No objection, Judge.
All right, that will be agreed. 42.
We would object to this one, Judge.
And what is the objection?
He's asking for information on another individual. I believe or I'm pretty sure it's the defendant's father. But he's asking for pretty much all of their everything criminally related to them.
All right. Is there a reason there's a request for something related to the defendant's father?
Yeah, because his father's the one who is the shooter in this case. And he has admitted it to other family members. He's known to have an AR rifle. He owns a black Audi that my client has never been in, never touched, was never registered him.
Well, when you say all police reports, it would have to be police reports that are related to this case, because I don't know how you.
We believe that Mr. Corwin Senior was arrested in May of this year. And we had got information that when he was arrested in May, he had an AR rifle.
So then you want the May report.
I want that report and any other arrest, because we also believe he was arrested in July of this year also.
All right, that's something that you need to subpoena. That's not something that the state would have. State, do you have information on Corwin Campbell Senior?
Judge, I believe he has 2 cases pending here. I don't know if he has cases in other counties or other locations.
Okay. So, and those 2 cases that are pending here, what are those cases?
A DWI, I believe.
And what else?
I think they're both DWIs. correct?
Okay, so counsel, that can be obtained by you through subpoenas.
To the SAPD or whatever jurisdiction.
Yes.
that arrested him. I'd like to, if you permit, I'd like to go back to 37.
All right, just one second. We'll go back to that. 42 is denied. 43,
Agreed,
44.
agreed.
All right, and you want to go back to number 37? Yes.
The state has told me that my client, Mr. Corwin Jr., was connected to this case by a registration of that license plate that's identified here for a 2006 Audi. Now, when my investigator ran the registration on that license plate, it came back to a Corman Damon Campbell at an address at Benzingle. I want to see what the Detective Martinez or anyone acting on his behalf saw that connected my client to that 2006 Audi. And I believe what it should show is the same thing my investigator found, that it came back to an address at Ben Zingelman, which my client has never lived at, that his father used to live there.
Okay, well, that should be taken up on cross-examination. So that will be denied. The next thing I have is defendant's second amended discovery motion. Have parties had a chance to review that?
Yes.
Yes, Your Honor.
All right, number 1. I think this has already been addressed in the,
Yes, that's already been addressed.
so are you withdrawing it from this motion?
Well, I'm going to seek it through other avenues.
Oh, okay. So it's withdrawn from this motion.
This motion. But again, I'll be seeking body cam videos, et cetera, because if he was arrested in May and if he did have an AR rifle in his possession, the body cam may show that, or the COBAN may show.
Okay. All right, number 2.
Judge, we've agreed to allow him to view it.
Okay.
That's
And so,
All right. And it has in here that it's for review only.
yes, Your Honor.
Number 3,
Agreed,
4.
object.
All right. Is this the same thing that we discovered in the other motion?
You know, I think it may be a duplicate of that, Your Honor.
All right. Are you withdrawing it from this motion?
I will withdraw it from this motion at the present time. Because again, I want to know if any of these witnesses, and these witnesses are alleged eyewitnesses.
Mhm.
If anyone from the DA's office or law enforcement has told them not to speak to me or my investigator, because he's having trouble contacting some of these. So at first they would talk to us and now they don't want to talk to us.
Okay. All right. Number 5. I think this was already addressed in the other motion.
And they've agreed to that.
Have you agreed to 5,
Yes, Judge.
6?
Object.
All right, and then that's the same thing. Counsel, I believe you said there was no CAD system.
Well, this is the system that I believe the law enforcement Detective Martinez used to connect my client to this 2006 audit. And I want to see exactly what Detective Martinez saw, because he would have seen two names.
All right, well, state,
Campbell, same name.
are you able to get a printout? Do you know if you can get a printout?
I don't know that, Judge, and so that was part of my objection. 1, 6 and 7, I guess, relate to the same thing. 6, he's asking for the time and the date, and so we would object to, he's pretty much
All right.
asking us.
So 6 and 7. State, when will you be able to call to find out if there is some printout or not? Because what defenses seems to be telling me is that his client, some officer looked at this system and decided that this audit came back to his client. And so he is entitled to see if it's available, what was ran to say that this vehicle is this defendant's vehicle.
Yes.
So when will you be able to know if they're able to print some out for this system?
Judge, I believe that I could ask any officer for that, if that's able to be printed. My second concern was if that, again, because it's something that law enforcement uses, if that's something that needs to actually be ordered. I didn't just want to provide something that I shouldn't legally be providing.
Oh, no, I'll order it. Are you agreed to 6 and 7 then, if possible?
I'm agreed to 7, Your Honor.
Okay, 7 is agreed to. And is there the date and time that, okay, so here's the thing, the date and time that the law enforcement utilized that system. As far as the date and time, I'm assuming that if the time is not on the printout, then who knows what time it was done?
I'm not that concerned about that. I just want to see what Detective Martinez saw that connected that audit to my client.
So are you withdrawing number 6 and keeping 7?
Yes, keep
All
it
right. Number 8.
Same objection as to time and date. And then 9, again, it's sort of, they go together. If it's a document that can be printed out, we would. Concern is, again, the law enforcement part, and if it needs an order.
I'll go along with that.
Oh, so you're withdrawing 8 and 9?
No, 9, I'll keep 8.
Okay,
Want to see that document.
all right, 8 is withdrawn by defense. And state, are you in agreement with 9?
With the court order, yes, Judge.
With. All right, so, and number 6, back to number 6, I'm sorry, back to number 7. That's agreed with court order. Of course, if they don't need a court order, then they'll proceed without that, and someone needs to provide a court order to the court. Number 10.
Object.
If I may explain.
Let me read it first. Let me see. All right, defense.
Your Honor, as you recall, the judge signed an order ordering the production of geographic cell site location information from T-Mobile. And after getting that order, we sent it to T-Mobile, and they immediately, within 2 days, sent us a printout. However, they admitted that it was not the geographic cell site location data, but it was the calls that were made by Mr. Corwin on the time frame of December 12th, 2021 to December 13th, 2021. I then requested T-Mobile to give me the geographic cell site information, and they're telling me now that they only keep it at T-Mobile for 90 days.
Just 1 second, I'm sorry. I'm sorry, I'm presiding judge, so I have people who are requesting things from me. All right, so could you continue?
So we are still working with T-Mobile, hopefully to get that data. Now, keep in mind that, in my motion, although the order doesn't say this, on November 1st, 2021, Detective Martinez, who was in charge of this case, contacted my client on his cell phone and talked to him on that date about this alleged shooting in September. And my client denied it. And so he knew that there is these software programs that I've identified.
So
here.
what specifically are you asking for?
I want to know whether or not the Detective Martinez ever saw, because he had two witnesses on this case who described two different people. One witness said that the person that was driving the car was a black male, bald, wearing glasses. That's the exact description of his father. 30s.
So what, but specifically, what do you want from
I want to
this?
know if the detective used any of these resources to get the geographic cell site location for Mr. Corwin, because he had his cell phone number, when he realized that there are two witnesses with different descriptions.
Okay, so that's something for cross-examination.
Well, okay, well, I'm kind of, I'd like to know whether or not they even attempted to get this geographic cell site
Okay,
information.
that'll be cross-examination number 11.
No agreement, Judge.
All right, is this the same as 10?
I would want to subpoena the person at SAPD that handles these software, Cellhawk, Hawk Toolbox, Swordfish. That's the data, and I'm pretty confident that SAPD uses one or more of those.
All right, do you know who the person is?
I don't, Judge.
All right, so,
I'll subpoena them.
all right, if you know who the person is, discover who the person is so you can give him that information and he's to subpoena that person, and whether they testify or not is.
Judge, I mean, this isn't, I guess my objection is that it's not a document, it's not any sort of evidence. He's asking me to do work that he could do himself.
No,
Same
that's
thing
what
that
I'm
he's
saying.
asking me to do is
No,
to
I
call
understand.
SAPD and find out. He could. do
Here's the
that.
thing, I'm not granting the motion. What I'm saying is, if you have that information of the name of the person, give it to him and he will subpoena that person. If you don't have it, you don't have it.
Yes, Judge.
All right. Number 12,
In agreement, if we add the words in regards to this case.
That's fine.
okay. Number 13,
Object.
I'll withdraw 13.
all right, that's withdrawn. 14,
We agree to any written reports.
Fine.
okay. $15,
Agreed.
$16,
Agreed.
All right. So those are the only two motions that the court has. Is there anything else?
Right.
All right. So where are we on discovery? Has all discovery been received or we don't know yet?
I really can't tell you. I'm not.
All right. So Ms. Ferguson, we're going to call this in 30 days for discovery. And Mr. Latimer, let the court know if you had any trouble discovering who that person is that you need to subpoena. All right, we'll come back on November 3rd. Thank you. All right, who's here on Victor Gelman? All right, Victor Gelman. Court is calling 2020 CR 3429, State of Texas versus Victor Gelman. Could I have parties announced for the record for the state?
Stacy Harrington.
For the
Jim Oakley,
defense?
sure, for Mr. Goldman.
And are you Mr. Gelman?
Yes.
All right, Mr. Gelman, you entered a plea of no contest on August 30th and you applied for deferred adjudication. According to the plea bargaining agreement, punishments be assessed at 6 years in the prison. There's a $2,000 fine. State is silent on your application. There should be Chapter 62 registration and no contact with the complainant. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, defense, do you have any witnesses?
May we proceed, Your Honor?
Yes.
Thank you. Mr. Gilman, going forward.
Oh, did you want to call him as a witness or no?
Yes.
All right, could you raise your right hand for me, Mr. Gelman? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Victor Gilman.
Mr. Gilman, you've had an opportunity to go over what I'm holding in my hand. You're reviewing and have reviewed before we came up here that early. Both the TAP evaluation, I'm holding it in my right hand, and the PSI in my left hand, correct?
Yes.
Do you remember when we were talking a few minutes ago, you had told me, and I was a little unclear, but maybe we can make it clear at this point. You were referring to the TAP and you wanted to make a correction, or there was some type of clarification, I believe, that you wanted to point out. Is that correct? Did I understand you correctly? Under the substance abuse history?
I can't.
We can't hear you.
Just make sure you speak up.
I just couldn't remember what the question was.
Okay, the question that you were asked by the TAP evaluator.
Yes.
And they were, I mentioned to you that this was a self-reporting substance abuse history, like the heading says. They're asking you about your personal use of any type of drugs, alcohol, correct?
Yes.
I understood you to say there was something you wanted to correct. Did I misunderstand you?
No.
Is everything okay
Yeah.
on this?
Yeah.
Okay, that's fine, thank you. Mr. Gilman, if you were, I see that your permanent address lists you in Lebanon, Ohio. Can you tell the court you have any current address? Where, in other words, if you're on probation, where would you be living?
19126 Salado Canyon.
Salado Canyon, is that here in San Antonio,
Yeah.
Texas? And who would that be with?
My parents.
Your parents are here? Okay. And are there anyone underage at that address?
No.
Just you and your parents would be there?
Yes.
Okay. Do you have brothers and sisters here in San Antonio as
No.
well? How long have your parents been here in San Antonio?
5 years.
5 years, okay. So your Lebanon, Ohio address was your previous address is all this means when you asked that question about your permanent address, right?
Right.
And the current address, of course, listed in the Bear County Jail, but I wanted to clear up that you did have a local address, correct?
Yes.
Mr. Gillen, were you working when you were arrested on this case?
Yeah.
What were you doing?
Food delivery.
Well, okay, tell me a little bit about that. Was it from a restaurant, a grocery store?
Oh, no, it's independent food delivery.
Independent food delivery? Was it from a company? And if so, what was the
Yeah,
name?
Uber Eats.
Uber Eats?
So did you drive a vehicle to make those deliveries? Are your own vehicle? How did that work? Okay, so people would order food, Uber Eats would pick it up and you would take it, all right? Was that a steady job?
Yes.
How many hours a week do you think you worked, just roughly? 50 hours a week? Was it a pretty decent paying job?
Yes.
Okay. Now, you realize from reading the TAP evaluation of the PSI, that there's a number of things in here with regarding the issues in the case. You read all that, and you accept everything that's in there, correct?
Yes.
So, Mr. Gilman, it looks like we have a case in terms of priors that is a little bit puzzling, and I think it was at the time. Maybe you can help us understand it a little bit better. When we get to your criminal history, it talks about, it looks like one case, that might have been a drug case for 160 days. Am I reading that correctly?
Yes.
Could you enlighten the court a little bit? Is that a misdemeanor or a felony case up in Ohio that you did 160 days on?
It was actually Illinois.
Illinois?
Yes, and I believe it was a felony case.
Okay, you believe it was a felony? It's talking about cannabis. That's why I was asking. So I'm a little confused, but it does list a manufacturing delivery. And the amount looks like it would have been more than a misdemeanor, but I wanted to ask for sure. So you got 24 months probation, 180 days in jail. And this is 10 years ago, right?
Yes.
Back in 2011. What is it?
10 years.
Okay, so on the notation terminated, I assume that's probation terminated, August 2011. Does it help to refresh the memory by? Does that make sense to you, that date in that charge?
Yes.
The only one that appears to be here out of state. Now, when it says terminated, it says 24 months probe, which is probation, starting in August 2009, and then the probation is terminated in 2011. Does that mean it was terminated successfully, or does the 180 days jail mean that's how it ended, with a bad end of your probation? Can you tell the court about that?
No, I ended the probation successfully.
Okay, so the 160 days jail was maybe time you did before you got the court, or how does that? how can you explain?
Before I received probation.
Okay, because it does say exactly 2 years later, 24 months probation terminated. So I'm assuming that means it was terminated successfully, right? Not revoked?
Yes.
Do you understand what I mean by that? Okay. Now locally here, you have a misdemeanor, 2019. And you didn't have any probation. You got 2 days jail. It looks like it was somewhat right before COVID. I'm pointing with my finger here, 2019. Okay.
Right.
So that's the only case you've had. No other cases in the state or locality. Okay. Mr. Gilman, do you want to be on probation?
Yes.
You make a comment in here that something about you think you'll be really good on probation. I think it's the last page, maybe. They're asking you a question. And let's see if I can find it. Do you remember what you told them?
I do.
You remember what you told them?
Yes, I do.
Can you tell the judge, it says here, I feel I will accomplish everything that is needed.
Yes.
And it's in quotes. Tell the judge what that means to you, if you wouldn't mind telling us that.
Anything needed to finish probation successfully, Your Honor, I feel like I've been able to accomplish it.
Are you a great believer in being able to do that? You think you can do it? You've done it once before, it looks like.
Absolutely.
Is there anything that you'd like to tell the judge with regard to her decision that you think that she needs to know that we haven't brought to her about why you need to be on probation and how much you want to be on probation? Okay, but sincerely, when I talk about those.
All right, so here's the thing. Mr. Gelman, you're gonna have to stop mumbling because the court reporter cannot hear you, okay?
Okay.
All right, defense.
Sorry, Judge. Just to conclude, how important this is to you. I know you've told me it is. You've opened up with me actually a lot better than you have with the judge. And I'm attributing that to you being a little nervous and concerned. Is that a fair statement?
Yes.
Is there anything else that the judge needs to know before she makes her final decision about why you need to be on probation? Anything from you?
I don't think so, Your Honor. I think I've said what I needed to.
In your statement where you're ready to throw yourself into this and do whatever you need to do exactly the way you did 10 years ago
Right.
with that drug case.
Right.
Thank you, Judge. That's all we have. I'll pass the witness.
Well, we're silent, Judge, and the only thing that the state would comment on based on his questioning is it was the state's belief that his parents sold the house on Salado Canyon, moved to Ohio, and he moved with them. And he has asked his parents to come back down here should he be granted probation. And his parents have told him they cannot do that. His mom can come for a few days, but they cannot move back down here for him for while he's on probation. So I'm not sure if where the information is coming from, that the parents still have the house on Salado Canyon. There was a deed transfer through the Bexar County Appraisal District showing someone unrelated to them having purchased that home.
All right, thank you. All right.
Judge, may I conclude with
Yes.
one thing I forgot to mention? Of course, on page 4, I know the court is taking careful note of this.
Yes.
But there's been no contact made with the victim, no response on multiple times.
Yes. All right, this is what the court is going to do. The court is going to deny your application, find you guilty. There's to be chapter 62 registration, $2,000 fine, time and money run concurrent. No contact with Aaliyah Ortiz, credit for any time served, 6 years in the prison. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Gelman, here's the thing. And I tell people this all the time, because this is what my mom and my grandmother always said to me. You can't build your happiness off somebody else's misery. So you had someone in a parking lot whose father was selling her for $1 to provide sexual favors to people. Even if you did not know that person was underage, you should have still said no, because someone is selling their body for $1. And then to chalk it up, not only is that you didn't use any type of protection, which means she could have some sort of disease, or she could have given you some sort of disease. And also she could be pregnant. You understand?
Yes, Your Honor.
So you're going to have to make better choices, and don't ever try to build your happiness or a minute's pleasure of happiness off someone else's misery, because I'm sure that's very miserable for her. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge. May I be excused?
Yes. Jody Ochoa. Jody Ochoa. Who's the attorney for Jody Ochoa? All right. What is happening with this case?
Good morning, Your Honor.
Good morning. What is happening with this case?
Today, our understanding is it's the first setting. Today is my very first day back at work in 7 months.
Okay.
I've been out on medical leave. And
It's good seeing you.
I beg your pardon?
I said it's good seeing you.
It's good seeing you as well, Judge.
All right.
I promise you that.
Ms. Perkins, can we have a 30-day reset? All right, so we'll be back on November 3rd, and that'll give you more time to look at any evidence the state may have.
We appreciate that, Judge. In the interim, Mr. Ochoa is in Corpus Christi with a facility called Victory Gospel International Spiritual Growth Center.
All right, he can.
Participant in that program. He'd like to return to it between now and the 3rd.
All right, Mr. Ochoa, you'll be allowed to participate in court by Zoom instead of driving down, okay? All right,
Appreciate it, Judge.
Thank you.
so much.
and Ms. Ferguson will give you a reset form.
Perfect. Thank you, Judge.
All right, Ms. Ferguson, can you note that he can appear by Zoom? Talila Harris. Talila Harris.
That's me, Your Honor.
All right,
And can I pass something
yes.
that has nothing to do with the case?
Thank you very much.
On Mr. Harris, I had filed a motion to change bond conditions to remove the GPS because the co-defendant had the GPS removed. And Mr. Harris doesn't feel that it's really in his best interest to continue to have this GPS on because it's impeding his ability to do work outside of Bear County without asking for permission.
All right, so we can do a tracking. Because before I change the bond conditions and remove the GPS, I'll need to have a evaluation for a PR bond just to see if it's appropriate to remove the GPS. So what I can do is if both sides are in agreement, I can do tracking only and we can come back once I get the PR bond evaluation to see if it's appropriate to remove it.
Well, and the state was in agreement to do tracking only,
Okay.
but Mr. Harris would like it completely removed.
All right, so Mr. Harris, I'm going to do tracking only. And then
Oh, well,
once,
he's saying he already has that.
I'm on track.
all right, so once I have the PR bond evaluation, I'll be able to make a decision whether or not it can be removed. And the case law in the legislature has decided that we need certain information in order to do that. Otherwise, I would base my opinion upon your case and the agreement between the state and the defense, but I'm not allowed to do that. So Ms. Fergus, can you see when we can get a PR bond evaluation for Mr. Harris and tell them, I know he's already on bond, but I just needed to make a decision on whether or not to remove GPS. I can also have it referred to Judge Carruthers and he may be able to do it sooner.
I can do that as well, whichever is easier.
All right, let's refer it to Judge Carruthers. Okay, and that's just for removal of PR bond. I'm sorry, for removal of GPS. And defense, do you have all the discovery in this case?
I believe I do. The file's a little fatter than the stuff that I got on e-discovery, but I'm not sure if all of this is just like key cards from the police department.
Okay. All right, so Ms. Ferguson, let's reset this for 30 days for discovery. And since it's, I'm sorry, when? All right, we'll come back on November 3rd. If your client is he working out of county?
I do conferencing now, so I'll build different, I'll build house.
Okay, all right. So we'll be back on November 3rd, okay? All right, thank you. A query? All right, counsel, where are we on discovery?
Judge, I produced some discovery to Mr. Sanders today.
Mhm.
I think we're both processing it. Maybe that I need to ask the court to consider appointing an expert to have a cell phone extraction done on something, but
Okay.
trying to avoid that if possible. So
Okay.
I don't want to slow, Mr. Akita's in jail. I don't want to slow the process down, but if we could have another discovery setting.
How much time?
I don't know, Judge. However much time you'd give us, Judge.
All right,
Our
let's
plan-
do this. Let's set it for 30 days and we'll see where we are.
Sure.
All right, Ms. Fergus, can I have a 30-day reset on a query? All right, we'll come back on November 3rd.
Judge, my client understands it's to his benefit to work
All right.
through this thing.
Thank you. And how do you pronounce your name
It's almost bossy queries.
and last name?
Query.
Equerry?
Yes, ma'am.
Okay, thank you.
Excuse me.
Yes. Thank you. Valdez, Taylor Valdez. All right, today is the plea deadline date. What is happening?
We're gonna plead, but I would request the court to allow us to come back next week, October 6th. You'll have the paperwork ready. She has some misdemeanors set that day, and we're gonna take care of everything. I'd like to take care of everything on the same day.
All right, Ms. Ferguson, are we able to do this on October 6th for a plea? All right, so we'll be back on October 6th. Come here first.
We will, and we'll be here on time, or at least she will.
Oh, no, Mr. Kalfas,
Yes, ma'am.
I need you here on time. Otherwise, I'll contact St. Mary's.
That's fine. Judge.
Okay. She needs to get a reset form. Oh, thank you. Can I see that? Let me write on there for Plea. Hernandez. Who's the attorney on Roland Hernandez?
Neil Kalfas also.
All right, what is happening with this case?
This state should dismiss it, but we were offered a.
All right, what is up with his T-shirt? What does that say?
That's my phone line. Barber Hustlers.
All right, we're not here for you to pick up.
I'm sorry, man. Apologize.
All right, so you can zip the jacket up. We're not here for free advertisement, Mr. Kalfas. So,
If we were gonna do that, Judge, we would have put Calfus Law Group on there.
okay,
Or vote for Stephanie Boyd for 187 District Court.
okay. All right, so on Mr. Hernandez, where are we? Have you received all the discovery?
I think I have.
I'll double check.
All right, has a plea been tendered?
Today, yes, ma'am, Judge, and I'm not trying to delay anything, but I just signed on to the case today, and we did have very meaningful discussions, both the defendant, myself, as well as the state. But I'm not up to par as I sometimes am on cases.
All right. Ms. Ferguson, can I have a 30-day reset on Mr. Hernandez for a plea deadline date? All right, we'll come back on November 4th, and that will be your plea deadline date. After that, the court will not accept any plea bargain agreements without good cause. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, what page is he on?
Page 25.
All right, we will see you back then.
That'd be excused, Judge.
Yes,
All right, thank you.
thank you. Have a good one. Monique Rowley Williams.
Judge, Mr. Williams, or excuse me, Ms. Williams incarcerated on a motion to revoke. We are here presently asking for a bond.
All right, so a PR bond needs to be filed so I can look at what's the appropriate bond. And I know it's deferred adjudication, but we'll probably be able to get that done fairly quickly.
What did you mention?
A PR bond. I'm not saying I'm going to give her a PR bond, but I need that document to make sure I know what's the appropriate bond to set for her.
Oh, okay, okay. I wasn't,
We have, that's the way I do it in order to get the information as quickly as possible.
So you want me to come back Monday or?
Just ask Ms. Ferguson when she would perhaps have that, so we could do that. Yes. Or either we could refer it to Judge Carruthers.
Whichever is the quickest, honestly. She got picked up last night.
Do you think Carruthers would be quicker?
It's up to you.
All right, so we'll do a request for a PR bond, and Ms. Ferguson will put it back on the docket.
Okay.
All right, thank you.
Excuse, Judge.
You may be excused.
It's been a while. Thank you.
Oh, thank you, you too. This is the court's last case, then the court is going on recess and everybody else is going to have to come back. Melissa Carlson. State, do you have the file on Melissa Carlson?
We just got it down here.
Have you had a chance to confer?
We have conferred, Judge. I don't have an offer for her yet. She brought me, defense counsel brought me some information about her review of the file, and I told her, let me look into those things, and then I can get her an offer by next time.
All right, Ms. Ferguson, can I have a 30-day reset on Carlson? Yes. All right, we'll see you all back on November 3rd. At that time, make sure that everybody has all the discovery and state will make you an offer.
Perfect. Thank you, Judge.
All right, thank you.
She's just going to the bathroom.
Ms. Ferguson told me that you might call me up for Carlos Castillo's.
Yes, on Carlos Castillo. Where is, he's not here, is he? All right, Carlos Castillo, can you come forward? I think we've already had this discussion
Yes, and
about
so-
his case being,
So I've got, Mr. Kalfas was the surety on it, and he signed off that he's okay continuing on the same bond amount and the same bond number. I've sent that to Mr. Salinas. He's out to lunch, and so I don't have his signature yet. Once I get it from him, I can file that for you. I didn't know if you just wanted to do that today.
oh, no, I just wanted to make sure that he didn't have an issue where he was going to be somewhere and all of a sudden he gets arrested. And I want him to be aware of that.
Okay. Yes,
All
Your
right.
Honor. Yeah, as far as I'm aware, he's still on bond, like, as far as the computer shows, he's still on bond, full house arrest under the MTR. It
Okay.
hasn't been discharged at this time, and so I thought we could continue on that until I could file that motion, I guess, with you and see what you wanted to do with it from there.
Okay.
Okay.
All right. Thank you. Thank you. All right, Norma, do we have anyone else remaining? Okay, and that's the only one? Yes. So Norma, the cases that are remaining, they'll need to be recalled for next week. Okay. And if I could see those, the remaining ones, so that I'll know that they were not here. All right, so everyone, I guess we'll be back on Monday. You know, I heard people say have a good weekend. I forgot it is Friday. Oh my gosh,
You were saying yesterday it was
pre-Friday.
Friday or.
You know, sometimes you anticipate and you forget the actual present. So the actual present is Friday. I got blinded by the wrapping paper with pre-Friday.
And Hocus Pocus 2 is on Disney Plus today.
Oh my gosh. Hocus Pocus 2.
I'm excited about that.
I'm super excited.
Well, here's the thing. I'm in the twilight of my life, so I need someone else to review that before I spend an hour watching it.